Good morning again. We are on the record, and we will be starting today's docketed items. The first docketed item, docket number 2022-017, cause number 379-03, has been dismissed with prejudice, and I believe that's all we need to note on that issue. Item number 2 is docket number 2023-022, cause number 471-03, in the matter of the request for agency action of Heavy Sweet Oil LLC and AC Oil LLC for an order establishing the Asphalt Ridge Enhanced Recovery Unit for the in-situ production of heavy oil from sands from the Rimrock and Asphalt Ridge deposits in sections 22 and 23, Township 4 South, Range 20 East, Uinta County, Utah. Before we get into this, I believe Ms. Garrison would like to make a statement.
I want to disclose that I was the Assistant Director for Oil and Gas at Sitla in 2018 and worked on the Hoodoo leases and the agreement between Hoodoo and Sitla. I did not work on the oil or the tar sand leases. I'm just disclosing it. If you have any objections to my participating, please let me know, or if it's all right for me to proceed, let me know.
Yes, so please let us know, are there any objections from any party here?
Chairman Gordon, we have no objection. There we go. Chairman Borden, this is Denise Dragoo, and I represent AC Oil and Heavy Sweet Oil in this proceeding, and we have no objection.
Fred McDonald, representing Hoodoo Production and Mining Company, and we have no objection to Ms. Garrison's participation either.
Thank you.
Paula Ferber, representing the Division of Oil, Gas, and Mining, and the division has no objection.
Okay, thank you very much. With that out of the way, I will now ask for presentation of council.
Very good. Chairman Borden, that maybe perhaps we'll begin. And I just wanted to indicate that Jim Allen and I are both here on behalf of petitioners Heavy Sweet Oil and AC Oil. And just to give you a little bit of background, the last time that Heavy Sweet and AC Oil appeared before the board was back in October of 2022. And at that time, the petitioners were seeking approval for a pilot project for enhanced oil recovery for the Rimrock and Asphalt Ridge Formation. And the board heard testimony on that matter, and in December issued an order approving petitioner's pilot project. Part of that order was actually an invitation that should petitioner want to return to the board when it was ready for a unit operating agreement, that the board would entertain that petition. And that's what we've done. We've filed now petitioners are ready to proceed with a unit operating agreement. And so we've filed a new request for agency action regarding seeking a unit order for the Asphalt Ridge Enhanced Recovery Unit. So that matter, the technical hearing to support that matter is not before the board today. We'll be presenting that probably in August or sometime sooner. But that technical hearing will be held at a later date. And today's hearing is really focused on the parties to these proceedings. And Hoodoo Mining and Production has objected to the unit order, but had failed to participate in the earlier board proceedings, which approved in situ production of the heavy oil from the Asphalt Ridge Formation. So today's hearing is really focused on...
Ms. Dragoo, I'm sorry, before we get into the nitty-gritty, I think we need to complete the appearance of council.
Oh, okay.
I know
Let's
we kind of got a half appearance of council
okay. Great.
with
Sounds
regards
good.
to Ms. Garrison, but...
Thank you, Mr. Chairman. Fred McDonald of Council with Lear and Lear on behalf of Hoodoo Production and Mining LLC. With me today is also Ms. Ginger Utley, who is co-counsel. Wanted to introduce her to the board as she will be appearing on matters on behalf of clients as we go forward, but she was assistant co-counsel in this as well.
Thank you.
Paula Ferber with the Utah Attorney General's Office, representing the Division of Oil, Gas, and Mining.
Perfect, thank you. That was just a formality we had to get out of the way.
Oh, very good.
Apologies.
No, that's great. Thank you,
So
Chairman.
back to you, Ms. Dreger.
Thank you. Yes, so today's hearing is not going to be focused on the technical hearing at all. It's just focused on our motion to strike. We have filed a motion to strike Hoodoo's response in opposition to the unit order. And really, there are three reasons. First, because we think that Hoodoo is a bit late to the party, that they did not participate in the earlier proceedings, which resulted in the board's order in December. Second, we think that the board probably lacks jurisdiction to address the issues raised in Hoodoo's response with respect to the respective leasehold rights. And finally, we believe that the Hoodoo's response fails to show that its oil and gas interests are affected by the unitization and tar sands formation. So Jim Allen with Snell and Wilmer will provide, he's put together a PowerPoint presentation addressing these issues. And after his presentation, and then we probably will hear a rebuttal from Hoodoo, and then we'd just respectfully request 5 minutes to respond to that. So I turn it and go over to Jim.
Thank you. As Mr. Gu mentioned, this is the second appearance before the board of Heavy Sweet and AC Oil. We were here in October making a case for approval of an enhanced recovery pilot project, as you recall. The order approving that was entered in December. It approved a steam injection enhanced recovery pilot project on 4 40-acre tracts. 3 of those tracts were on SITLA surface with SITLA leases. A 4th is on private mineral, private surface. The order granting approval to proceed with the enhanced recovery project was conditioned on approved APDs and approved underground injection permits. Those applications and approvals are still in process. As I mentioned, the hearing was held in October. The order was approved in December. And then you might recall Heavy Sweet petitioned for a spacing order covering 2 full sections in the same area. After consulting with the division, we withdrew that request, thinking that unitization was really a much more efficient way to accomplish what we were trying to do. And so we filed this unitization proceeding that's in front of you now. Heavy Sweet's objective in that is just to get out ahead of the lead times, and it's their expansion of the pilot project. So still in the approval stage on the pilot project for the wells, but looking to move to the next stage, and that's why we're here today for unitization. Just to mention some of the key findings from the board order. First, in the board's conclusions of law, they invited Heavy Sweet to return and seek a unitization order if that was appropriate. So this is very much a follow-on to that action. In the findings of fact, Hoodoo's leases were looked at because they cover the same land. And in the findings of fact, it was determined that Hoodoo did not have tar sand rights under their lease, and that the target formations, the asphalt ridge and rimrock formations, consist of tar sand. And finally, we just note in passing that Hoodoo received notice of those proceedings but didn't participate as a party. You'll see this exhibit in the hearing on the merits later this summer, but this is just to let you get oriented to it. We're seeking a unit that consists of all of Section 22 and a good portion of Section 23 in Township 4 South, Range 20 East. You see there the 4 patterns that represent the 4 enhanced recovery projects we talked about in the earlier proceeding. So looking at the request for agency action that we filed. The relief that we sought that we are seeking is first designation of the asphalt ridge unit for enhanced recovery of bitumen and heavy oil from tar sand in the asphalt ridge and rimrock formations. The authority for this board to approve that is at Utah Code 40-6-8. At the same time, we're seeking approval of a form of operating plan and operating agreement. That is required under the same section of the code. And we would, of course, be requesting that approval of the form of operating agreement would be conditioned on approval by the working interest and royalty interest owners as provided in the statute. Which is to say, we have not sought any signatures on that agreement. We would like the board to see the form first, to talk about the plan. We recognize that we're very much breaking some new ground here. This is not the typical unitization operation. This is the state of Utah's first real effort in regulating tar sand under the new statute. So that's the way we wish to approach the unit operating agreement that we've submitted as an exhibit, or will submit it as an exhibit, I should say. The third relief that we're seeking is the subject of today's proceeding. We're asking this board to reject Hoodoo Mining's response objecting to the request. As you know, Hoodoo Mining filed an objection asking that you deny our request for unitization. And we're asking for you to strike that objection, essentially dismissing them as a party to this proceeding because they're not entitled to participate. And that's where I'm going to spend the rest of my time today.
Just to make it clear to the board, so really we're only focused on item number 3 today. The other ones are relief sought in the intermediate term.
That's correct. We have continued I guess the hearing on the merits, you might say, of the unitization request. So today, yes, we're only talking about item number 3. Here is the legal basis first for the unitization request. The board shall make an order providing for you the unit operation of a pool or part of it if the board finds that the operation is reasonably necessary and if the value of the estimated recovery substantially exceeds the estimated additional cost. Those are the things that will be required to prove when we return for a hearing, probably in August. Today, the key provision we're talking about is this provision of the board's rules that simply defines who may appear as a respondent to this type of request for agency action. And it's any person whose property interests may be affected by a proceeding initiated by the board or any other person. This is essentially a standing argument. If you were in court, you would call this standing, and it would be ruled by principles of common law. Here in an administrative body, who gets to participate is purely governed by the statute and the rules. And the rules are clear. To be a respondent here, you should have a property interest that may be affected. And our entire argument is that Hoodoo does not meet that standard. Now, I apologize for a really ugly slide, but this is the argument in a nutshell. It is our position that Hoodoo is not a proper party to this proceeding because they have no interest that could be affected by the proposed unit. And the reason they have no interest is because their leases explicitly exclude recovery from tar sand. And that, I think, is really the key point. I think both parties agree that the leases were drafted to be mutually exclusive. Either you're recovering tar sand or you're recovering traditional oil and gas resources. And we'll talk about the language of those leases in a minute. But our position is you can determine from the face of the leases who has a property interest and who doesn't. And the more complicated issues of jurisdiction or whether this should be heard in court really only come into play if you want to go below that bottom box into trying to construe Hoodoo's lease to pull them into the tar sand formation. And we don't believe that's necessary. Our argument here is simply, if you look at the face of the leases, you can tell. Yeah. And as we mentioned, the nature of the formation that we propose to unitize has been in front of this board recently. We presented witnesses in a proceeding that Hoodoo had notice of that went through the considerable evidence over decades that the Asphalt Ridge and tar sand formations, well-known tar sand formations in Utah, really do consist of sandstone or rock impregnated with bitumen or heavy oil, falling under the general rubric of the phrase tar sand. Considerable evidence at that point. The board made a finding of fact to that extent regarding the formations that we're here to unitize today. So we don't think the board needs to go there again. You've heard the evidence. The other party had an opportunity to participate, and the evidence is, as you heard at the time, was considerable. Many researchers have looked at this over many years. But as I said, this all depends on the leases. And in this case, both HSO and Hoodoo have leases covering the same ground, but leasing different substances. Here's the relevant language of HSO's lease. And I realize there are a lot of words there. I'll just stop talking for a minute and give you a chance to glance through that. The first key point, the lease grants the right to extract these substances, bituminous sands, which means rock or sand impregnated with asphalt or heavy oil and synonymous with the term tar sands. Call it bituminous sands, call it asphaltic sands, call it asphalt, call it heavy oil. It's all the same, it's clear that this is what the lease grants, everything that falls in this general umbrella or rubric of tar sands. And then the lease goes on in somewhat clunky language, I'm sorry, Ms. Garrison, to suggest that the lease does not cover certain things. Any liquid hydrocarbon which occurs naturally in a liquid form in the earth. Nor does it authorize recovery of gilsonite, oil shale, elaterite, ozocerite, or bituminous carbon compounds except rock or sand impregnated with asphalt or heavy oil, which dries to a viscous or a solid bitumen near the surface of the earth. That's what the Asphalt Ridge and rim rock formations were shown to consist of in the previous proceeding. Rock or sand impregnated with asphalt or heavy oil. So our position is that the formations we're talking about and the place we're talking about fall squarely within this granting clause. Let's look at Hoodoo's lease, one of Hoodoo's leases. Theirs is on a more typical oil and gas leasing form. They're entitled to recover oil, including all naturally occurring crude petroleum oil or other hydrocarbons, regardless of gravity if produced at the wellhead in liquid form. But down at the bottom in the highlighted sentence, the lease expressly excludes non-associated hydrocarbons defined herein as coal, bitumen, asphaltum, other associated heavy hydrocarbons occurring in tar sands, oil shale, gilsonite, all of which must be separately leased. So that's the core of our argument here today, and it's fairly simple. Looking at the face of the leases, which have been submitted to you by both parties, one party has a tar sand lease, one party does not have a tar sand lease. We're here in front of you in this proceeding asking to unitize nothing but tar sands. And so in our view, Hoodoo is an appropriate party to this lease or to this unitization proceeding. Now, let me address just one more point. I know that in some cases, when there is a dispute over ownership of a resource, it has been the practice of either the division of the board to say, parties, go off to court, you settle it, come back to the board when you've got an answer to this question. We would prefer you did not do that for obvious reasons. And here are the reasons why we don't think you should take that position today. First, as you see, HSO is holding a lease for tar sand. No question that it's a valid lease. No question that it applies to the substances that are in the ground out there. But more importantly, let me refer to the statutory basis for granting a unitization request. Going back to the statute, and this is an interesting situation because unitization is controlled entirely by the statute. The board hasn't really written rules governing the unitization process, but here's what the legislature said. The board shall make an order if the board finds two things. The operation is reasonably necessary and the economics are favorable, to summarize what the statute says. I suggest that shall make an order is mandatory language, that a party who appears before the board and can produce evidence so that the board can make those two findings is entitled to an order. And in that case, then it would be up to anyone who had that dispute to go ahead and take their case to court and determine whether they had an interest in the property or not. But fundamentally, this issue is simple. On the basis of those two things, the board shall make an order. So that is our thought. As I mentioned, much of the technical and geological and chemical and physical information about the deposit has been presented to this board before. We think the board is certainly in a position to take official notice of those facts, the findings of facts that were made before, and really doesn't need to hear that evidence again. So that really is our argument, the very simple argument that Hoodoo doesn't belong here because they don't have an interest that will be affected. And with that, I'm happy to respond to questions.
Board, any questions for legal counsel for Heavy Sweet? Yes.
Yeah, you've made the case that because of the language that's stated in the leases, that they don't have the hydrocarbons necessary. And you're also making the case for the unitization, which we need to set aside for today. But
Right.
Let me focus on the leases. Have you resolved this with SITLA? I mean, it is a SITLA lease that was issued, and it is their language. So what jurisdiction would we have?
None at all to construe the language of the leases. The leases are contracts. Construction of contracts is a task that lies squarely within the district courts of the state of Utah. And the general rule regarding construing contracts is you construe them according to the language in the four corners of the contract. And as long as that language is unambiguous, you wouldn't even inquire of SITLA what their opinion was. because you would simply construe the language of the lease. It's only if a court were to find that either those leases were ambiguous that they might take evidence on what the language might really mean, so-called parole evidence. And in that case, Sitla's views as the drafter of the lease would be relevant. But to answer your question, Ms. Sierra, none of those issues are the kinds of issues that we would expect this board to consider. They're the kinds of things that should go to a district court.
And I'd also like to add, this is Denise, that the board has already ruled that that HSO has that heavy sweet oil has the rights to develop the tar sands, and they already accepted the lease into evidence, and that was part of the board's order. So, so that's already essentially res judicata in this case. It's already been established.
Any other questions from the board? I have a question in that case. The definitions you provided were geologic descriptor definitions and maybe petroleum geology descriptions. Is there a stratigraphic break between, is there just one stratigraphic horizon or just two where the tar sands exist, and has that been well documented, and and is that separated from maybe the more traditional petroleum hydrocarbon resources that have been leased by Hoodoo?
Yes, and I don't want to run the risk of testifying
Okay.
to facts, but I feel comfortable telling you what this board found in December of 2022. They identified two formations, the Asphalt Ridge and the Rimrock Sandstone formations that contained sandstone impregnated with asphalt or bitumen or heavy oil. They defined those according to markers, as you would any other formation. Those formations are at 1,500 feet or shallower with respect to the surface. There was no water or any other hydrocarbons or between the surface and the Asphalt Ridge and Rimrock formations. If there was evidence presented on whether there were traditional oil resources well below, I don't remember what that evidence was. But if there is traditional oil, it's at a much deeper depth.
Thank you. Any other questions?
No, I think we'll reserve the rest.
Okay. Yeah, just to let you all know how this is going to work, we'll work through all the interested parties once, and then you will get a chance for rebuttal and some summarizing at the very end. So we'll work through everybody a second time. So over to you, Mr. McDonald.
Thank you, Mr. Chairman. I think you need some background a little bit, first of all, on the leases. The leases were issued in 2018. Hoodoo's leases were issued first, then the tar sands lease was issued, and the statute tying tar sands to enhanced oil recovery wasn't passed until 2022. So you need to keep that historical background in mind, okay? Mr. Allen showed you the quotes from the various leases, but of course, he emphasized what would be beneficial to his client versus what's beneficial and important to my client. Hoodoo's leases are ML 53172 and 53173 OBA, which were submitted as Hoodoo's Exhibit B. Those leases grant to Hoodoo the exclusive right to extract oil regardless of gravity if produced at the wellhead in liquid form. What is enhanced oil recovery? Producing oil, liquid oil, at the wellhead. It does exclude tar sands. We acknowledge that. But HSO's leases, and again, the other thing I want to point out here, we're not challenging AC's private leases. We're talking about the Sitla leases that are concurrent with the tar sands leases. HSO's leases exclude naturally occurring liquid hydrocarbons regardless of depth. And that is shown on Hoodoo's Exhibit C that was filed. HSO argues that Hoodoo is not a party to this unitization request and therefore not entitled to participate at all in the hearing because it has no interest in the tar sands. We are not arguing that they have rights to tar sands as defined in their lease. As you'll hear, we're arguing, we question whether there's a tar sands deposit, which is their requirement under the unitization statute to prove. Let's start again back with those regulatory definitions that the board has as what constitutes a respondent and what constitutes a party. Our 641, 100, 200 defines a respondent as a party whose property interest may be affected by the filing of a request for agency action. And a party is a respondent. Party is defined, and with all due respect to Mr. Allen, the site was wrong. It's not 645, it's 641, 101, 200, defines a party as entitled to introduce evidence, examine and cross-examine witnesses, make arguments, and generally participate in the proceedings. With those definitions, right then and there, the board's analysis should end and allow Hoodoo to participate and accept its response. Right there. What HSO is doing here is playing judge and jury on what are Hoodoo's rights and how they're affected by its application. If Hoodoo is not a respondent or party, why did they notify us? Why did they notify Hoodoo at all? If they thought they weren't affected, why were they notified? Why was Hoodoo included in the joint stipulations and motions in this cause up to this point? The bottom line is Hoodoo is directly affected by the unitization application if it proceeds with its operations and impinges on Hoodoo's rights. If there isn't a tar sands deposit, they're impinging on Hoodoo's rights. If the oil is mobile and it's produced at the wellhead, it's under Hoodoo's leases. We are directly affected by this cause. As stated, HSO seeks unitization under the statutes 40-67 and 40-8. As part of that request, it must establish there is a pool of the resource leased to it, which is tar sands. By filing this action separate from the one that was filed back in October and not including unitization with that request, HSO has opened the door to challenges on is there a pool of tar sand. Remember, their order only dealt with pilot programs on 40 acres, not the entire area. They have to prove there's a pool of tar sands in the entire area. By opening that door to challenge, Hoodoo is not precluded from challenging under any legal theory, whether it be collateral estoppel, administrative res judicata, or whatever. Administrative res judicata requires the issues in the prior administrative action to be identical to the ones in the latter action, and that those issues were completely, fully, and fairly litigated. And that's under the career services case that they cite in their brief. As outlined in our response to their motion to strike, the issues involved with what happened in October are completely different from the one that is pending in front of the board right now. This is a unitization request. Most importantly, you need to look at the order you entered in December. In finding of fact number 17, the board order provides the targeted formations are expected to be continuous in the subject lands. That's hardly a conclusive determination. HSO has not submitted a map, which is a structure map, which is required to illustrate continuity of the targeted formations across the entire unitization area. Order number 1 of that order says the request is conditionally granted, subject to the division's approval of APDs and UICs. Again, not a conclusive final decision. And as noted in our response, Hoodoo's already filed objections to those UIC permits because of faults we see with that. several new technical exhibits were submitted in this cause that the board did not review in the October hearing. All new evidence. Hoodoo, as I mentioned, is challenging the fact that there is a pool of substances leased to HSO at the targeted depths. In fact, utilizing the data supplied by HSO in this cause and is reflected by Hoodoo's rebuttal exhibit M, Hoodoo will prove there is no tar sands on its leasehold. Hoodoo is not asking the board to adjudicate the rights under the respective leases or to interpret those lease terms. It simply requests the board to in fact determine if there is a pool of tar sands, a decision totally within your expertise and which you are required, mandated, to make under the statutes that they seek unitization. Order number 9 of that December order expressly states that the board retains continuous jurisdiction over the matter. Each and every board order always provides for that to allow the board to consider factors which may subsequently arise or be discovered and revise its order accordingly. In a pilot program, that's exactly what happens. You gather data, and if your findings aren't there, then you need to modify it. HSO's position is basically if a petitioner can seek through an order without objection, even if that order is fundamentally flawed, then the board loses authority and jurisdiction to hear any objection to correct it. The board retains jurisdiction for that exact reason, to deal with that. In an absurd illustration of how that could be carried forward, if a party came and declared that the earth is flat and nobody objected to it, does that mean that scientific evidence clearly to the contrary can never be used to challenge? Or on a more practical note, in a forced pooling hearing, if it's discovered subsequent to the hearing that a party is actually leased instead of unleased and forced pooled and the time runs on it, does that mean the board can't come back and fix that and say, no, that party was leased and it was voluntarily pooled? You have that right. That's why you retain continuous jurisdiction over these matters. The board should hear all of the relevant evidence relating to determine whether there is a pool of tar sands covered by the areas under Hoodoo's leases at the depths proposed for unitization. That's why this should go forward with Hoodoo's participation, opportunity to present its evidence, opportunity to present its testimony, and to cross-examine their witnesses. I want to end on a note. Although we could not find any Utah case law directly on point, there is a 1981 Virginia case from the Virginia Supreme Court addressing how you're supposed to deal with a motion to strike. That case is Butler versus Yates, and the site is 281 Southeast 2nd, 905. And this is what the court said at that time. The standard by which a motion to strike should be judged is well settled. The trial court should resolve any reasonable doubt as to the sufficiency of the evidence in the objecting party's favor. Moreover, in ruling on a motion to strike, the trial judge, and this was a trial situation, is obliged to adopt those inferences most favorable to the party whose evidence is challenged, even though he may believe different inferences are more probable. So in this situation, the board, in dealing with a motion to strike, should look to all inferences in favor of Hoodoo, and only if it can say those aren't allowable, then we should be stricken and not be part of this. With that, that concludes our presentation, and we appreciate the board's attention.
Any questions for Hoodoo legal counsel from the board? Yes, Mr. Moon.
Why didn't Hoodoo respond to the original request for agency action? Why didn't you become a party at that point?
Well, they didn't figure at that point that the tar sands pilot program was going to be an issue. But then once it saw the evidence and saw what they're seeking here, there's a real question of whether there's tar sands on their particular lands. And as I mentioned, that was a pilot program for small 40-acre parcels and not the entire area that they're talking about here.
Okay. At 1,500 feet, or not asking you to testify, just give your general knowledge. At 1,500 feet, is traditional oil and gas being produced in Utah anywhere?
It's possible. I mean, again, I'm not a technical expert, but it's possible that that's the case.
Okay.
Any other questions from the board? I've got one question. You've said it a couple of times that Hoodoo believes there may be no tar sands present based on standard geologic definition of tar sands, or could you just
As it's defined in
explore
the, as it's defined in the leases.
Yeah, it's defined
And
in
that,
the
that the
leases.
tar sands are continuous at the depths that they seek the unitization. That's the challenge.
Mr. Mayor?
Yeah, any, is Hoodoo have any evidence of there being no tar sands?
Well, that's what we want to present. That's what the exhibits are and what our witnesses are ready to testify. And again, the burden is on them to show that, and based on what they filed so far, our witnesses and Hoodoo believes that they haven't shown that there's a tar sand deposit there. Or a tar sand deposit at the depths in which they talk about as tar sands is defined in their lease.
Okay. Does Hoodoo have any producing wells or any prospects in this unitization area?
Well, they're waiting, they do have plans to do that, but they're waiting because this is a problem with any development right now, until this is resolved.
Okay.
Is Hoodoo's position that there are no tar sands anywhere present in this area, subject area, or just not in the areas proposed for unitization, the broader area?
No, in the area right now that's covered by their leases, they believe that there is no tar sands at those targeted depths. Excuse me, or that it's continuous.
Okay.
So where Hoodoo's extracting in other areas, what geologic formations are you in? And in this area, what general depths are they at?
I can't answer that question. I don't know. That's a question that you could ask for Hoodoo's witnesses if we go forward. But again, today's focus should simply be is should Hoodoo be a party to be able to answer those questions and challenge whether or not there is a pool of tar sands for unitization purposes.
Any other questions from the board? Don't worry, you'll get another chance when we go through the round again. Are you complete?
Yes, Mr. Chairman.
Division?
Thank you. The division has reviewed the filing in this matter and is not taking a position on the motion to strike. However, the division questions whether Hoodoo can challenge the previous board decision based on the doctrine of res judicata. The time for contesting that matter has passed. There were opportunities for Hoodoo to participate in the initial hearing. There was a possibility of petitioning the board for reconsideration or petitioning the courts for judicial review, and that has not taken place. So the division believes that to the extent that the final order in docket 2022-024 conclusively established facts or conclusions now challenged by Hoodoo, the division believes Hoodoo is barred from relitigating those facts and conclusions in this proceeding. And that's all the division has at this time.
Board, any questions for the division? Mr. Galecki?
So they had an opportunity to participate both in October and December?
They had the opportunity to participate in the hearing, and then once the final order was issued, they could have asked that it be reconsidered or that it go forward with a judicial review.
Any other questions? Yes, Ms.
Was Hoodoo notified from day one when they started, back in October, that these proceedings were going on?
Yes.
Okay, thank you.
Anything else from the board? Yes, Mr. Moon?
I don't know if it's the right time to ask us, but I would just like to ask John Baza. He has a lot of knowledge going back of. Are you aware? Same question that I had over here. Are you aware of traditional hydrocarbons being produced from depths as shallow as 1,500 feet or less.
In this area, or
Yeah, in the Uinta Basin.
I'm not familiar enough to know that there's much in the Uinta Basin, traditional hydrocarbons. There is an Ashley Valley oil field which produces on the eastern side of the basin, but I think that might be a little deeper. But there are other areas of the state where we've seen hydrocarbons at shallower depths.
Okay. Okay, so you're saying it's possible, but in this area, you're not aware of any, but it could be possible then.
And we're talking traditional oil and gas production.
Right.
Yeah, again, my knowledge is somewhat limited about specifically what's going on in this area,
Yeah.
but I'm not aware of any wells that are as shallow as this.
Okay.
in
And
that
kind of a
area.
question for anyone, any like current wells being perforated and fracked at 1,500 feet and producing? Anything
That's-
happening right now?
Yeah, I guess I don't have that broad enough knowledge to be able to say for sure.
Thank you.
Okay. And division concludes?
Yes.
Okay.
Nothing further.
I guess we're back to heavy sweet for rebuttal, summing up, whatever
Okay, thank you.
information you'd like to transmit to us.
A lot to cover, but most of them are small points, so I'll try to move as quickly as I can. The initial question that arises in my mind after I listened to Hoodoo's presentation is, what is Hoodoo seeking here? What is the relief they're asking for before this board? Ultimately, they're asking this board to deny a unitization request for tar sand. And as I understand it, they wish for the board to deny this request based on evidence they wish to present that there isn't any tar sand there. The sort of flippant response to that is, if there is no tar sand there, then no harm, no foul. We're asking for a unitization that applies only to tar sand as the unitized substance. If it's not there, then, again, I don't think that would prohibit a conventional operator from poking a well down there and pumping their crude oil up to their heart's content. So that's the first kind of general objection. As far as the relief they're seeking, they don't need it. Second, I would point out that production of these particular resources, the Asphalt Ridge resource, has been sought for a long time. When I was an undergraduate student in the 80s, I worked on a project at the University of Utah, recovering tar sand by froth flotation, recovering bitumen out of tar sand by froth flotation, out of the Asphalt Ridge and PR Springs Formation. That was 40 years ago. There's been a lot published over the last 40 years about these formations. That information was summarized in the previous hearing. They all say it's tar sand. So really, you've got Hoodoo coming in here asking to make not just a late claim, but a fairly extraordinary and late claim. To turn to the absurd analogy, it would be as if, having made a finding of fact that the earth really is round, now at this late date you've got folks showing up saying, oh no, we have evidence that it's flat. Well, you can find that on the internet if you want to. But these things seem to have been well settled on whether the board is prohibited under res judicata from looking at these things, or whether the board simply does not need to because they've already decided them. I think we can move on without this additional information. Let me turn to the comment about the definition in the leases. So, could I have the screen back on again?
There we go.
Oh, thank you very much. Here's the language from the Hoodoo lease, I think. Oh, that's interesting.
There. You should back up.
Okay, I'm a little bit lost.
There you go.
All right, there we are. And they appear to be hanging their hat on the fact that they have a lease that entitles them to produce oil regardless of gravity if produced at the wellhead in liquid form. Well, no, let's back up in the sentence to see what other modifiers there are regarding this oil that's going to be produced regardless of gravity at the wellhead. All naturally occurring crude petroleum oil and other hydrocarbons. So I think the reasonable and comfortable reading of that language is if it doesn't naturally occur in a form that can be produced at the wellhead as a liquid, then it doesn't fall within their lease. So the notion that somehow the enhanced recovery by fluidizing or melting that very viscous bitumen and bringing it to the surface with this steam injection process, I don't think it's fair to conclude that act turns something that falls within HSO's lease into something that falls within Hoodoo's lease. If it doesn't naturally occur in a form that comes to the wellhead as a liquid, then our position would be that Hoodoo isn't entitled to it. So that's our comment regarding naturally occurring liquid. Obviously, why did we notify Hoodoo? Out of an abundance of caution. I mean, even if that was a mistake, you can't mistakenly admit someone else's property rights. Standing in this proceeding is defined purely by the rule in the statute, which says they need to have a property right that may be affected. And on the face of these leases, that we think that doesn't occur. There's been some mention made about continuity of the pool. To refer you to the unitization statute 40-6-8 3A. Hoodoo is required as part of their submission to provide evidence of a pool, pools, or parts of a pool. It would seem to me that with language that broad, continuity of the pool, while it might be important for spacing, isn't necessarily critical to unitization, because the statute calls for evidence of a pool, pools, or parts of a pool. So I think that's the issue there. Again, the board's heard plenty of evidence about what's down there. It's tar sand. And we think that based on that, the board should have to ask Hoodoo to seek their remedies somewhere else. Thank you.
Any last questions from the board for Heavy Sweet?
I do have one.
Yes.
If there had been a coal lease or a placer mining claim or something on those lands, would you have notified those lessees? Would you have notified everyone who had a potential interest in the lands of your project? Or did you just notify Hoodoo? That's hypothetical.
Yeah, it is.
Everyone that
We-
we notified in the spacing proceeding.
In the previous proceeding,
Right.
we notified more broadly.
Okay.
Because we were required to notify within a half mile of the proposed wells. And so we did notify all surface and mineral owners regardless of the ownership interest. In this proceeding, I think our need to notify was a little narrower because it had to do with whether they would be affected by the relief we're seeking.
But you would have notified people other than oil and gas people originally in your original
Originally, yes.
October?
Yeah,
Thank
had
you.
they existed.
Mr. Moon?
So if Heavy Sweet drills down 1,500 feet and finds naturally occurring oil or gas, what would they do? What would you advise that they do?
After they recovered consciousness from the surprise, we would suggest that they comply with the terms of their lease, which is that they would have to notify SITLA. And the term of the lease says that if you encounter a substance other than what you're entitled to produce, you're required to notify SITLA, and you may then seek a separate lease for that. But that would be what they'd have to do.
Is there any chance that the wellbore could be drilled and the process of steaming it started without knowing whether or not it was needed to be steamed? I mean, is there any chance that there could be a mistake between it being naturally occurring oil and gas versus heavy oil that had to be steamed to get out of the ground?
I don't think so. As I said, this deposit in this area has been studied. There's a lot of literature on it. There is or published, results of drill cores, things like that. There's a lot of information, and as I recall our witness's testimony, he had not found any evidence that there was liquid.
24-hour mobility test.
Yeah.
Agreed to that with SITLA.
Yeah, and of course, I should point out that HSO has agreed with SITLA to conduct a 24-hour mobility test on an actual sample to just determine whether the stuff is mobile at all.
Okay.
Yes,
you.
Mr. Clay.
Can you go back to that map that you showed for unitization?
Sure, I hope, well, I hope so. There we go.
So where was the pilot program?
The pilot program are the 4 honeycomb shapes you see,
Okay.
which would indicate one, I always get this wrong. 6 injection wells around the outside, 1 production well in the center. I think, don't hold me to that, it might be the other way around.
And so if I heard your last response a second ago, you're required by SITLA to take a sample to show what type of oil it is within 24 hours?
Not required, we've agreed to.
Oh, we agree to, okay,
Yeah.
thank you.
And how will you get that sample out if it's not? Oh, sorry. And how will you get, it'll be a core, I guess. It won't be pumped or anything because you haven't
Correct.
heated it or steamed it yet. So it'll be a core that you send, okay?
Yeah, my understanding is that they're in.
It's a 24-hour pressure test to show whether there's any inflow of fluid.
Okay. Right. My understanding is that they're in possession of a sample from one of the earlier wells
Okay.
in the area.
It's a 24-hour pressure. Should we have him indicate what that is? Okay.
So, I mean, just to clarify, the test is a 24-hour pressure test to determine whether, to what extent the material is mobile.
So it's just a viscosity test, it's not a quality test? Yeah, I'm just wondering
I don't
what test is being conducted?
It is a test to determine whether, under the pressures that you would encounter at that particular depth and other natural conditions, if the material moves.
So in other
so
words, is it a test to determine whether it falls under your lease or their lease? In
Correct.
effect?
Possibly. I'm kind of getting out to the end of
Yeah, right.
my board here.
Right, I mean, that's what SITLA should be concerned about, is whose lease
sure.
it falls under.
Yeah.
And so you're saying that is something that you've agreed to do?
Yeah.
To submit that to know, so that there can be a determination?
Yeah, for SITLA's benefit.
So looking at this map, the subject lands are not even quite 2 square miles.
Correct.
How many holes, if you've probably told us this 6 months ago. I apologize for my short memory. How many holes have been put through here to test out the existence of the resource to date?
I don't know. I know that there were holes that we had data for that were pretty close to the westernmost two. I
Okay.
can't testify on that, I'm
How-
sorry.
How about within this area, has there ever been any attempts, over the last 40 years at mining the resource and retorting it, or all those old techniques?
Oh, yes, yeah.
So that has occurred within this,
Yes,
this
that-
area?
that is occurring right near, as I remember, right near the center of Section 23, where the resource is a little closer to the surface, and there it is. They're out there digging it and running it through various sorts of machines, or have been.
And this may be a question for Hoodoo, but I'd love your thoughts too. Have there been any conventional oil wells drilled in these two sections that we're aware of, that you're aware of, and I'll ask.
I'm
that
not
same
aware of,
question to
but
you
then
eventually.
I'm not the right witness for that.
Okay. Thank you. Any last questions from the board?
Chairman Borden, I just had one clarification that SITLA has provided a letter dated March 3rd, 2023 to Hoodoo regarding the 24-hour mobility test. And it states, and this is Exhibit 2 in your packet, Valco offered to conduct a 24-hour mobility test for each well drilled on the cross-leased property. We've accepted this as an adequate test to determine whether Valcor will be mining mobile oil or bituminous sands. If Valcor finds mobile oil after one of these tests, the Trust Lands Administration will reevaluate the situation. So that's how SITLA's dealt with it, and it's in your packet, Exhibit 2.
Thank you for reminding me of that. Anything else from the board?
So I guess I could, but, so how is Hoodoo's interest not protected by not only the leases, but this?
Why don't we wait for
Okay.
them to
Okay.
do their sum up, and then we can ask
All right.
questions of them. So are you guys complete?
Yes.
Yes,
Okay.
thank you.
I believe the board's done with your questions, so we will move on to Hoodoo.
Thank you. A lot of your questions go to the merits of this, okay? Your focus today is, can Hoodoo participate as a respondent? Okay? If our interest may be affected, and if they drill into it and there's oil there under our lease, our property rights are affected. That's the point, okay? As to the collateral estoppel argument, we've already given you the status. You have to have the exact same issues. It has to be a conclusive determination. We've pointed out where the problems are with the December hearing. That was a pilot program, involved injection. This is unitization. It's a separate thing. They are required by the statute to prove it's a pool. We are entitled to our day in front of the board. Now, if you want to believe their evidence versus the evidence Hoodoo does and prove it, that's fine. But that's for the next hearing. Today is Hoodoo a party to this action? And that's where we're saying yes. And the board has the expertise to address, is there a tar sands deposit? Is there geological matters like that? Things like that. That's why there's an issue here, okay? So you've got to get past that step. When you get to the merits, that's up to the board then to decide whose expert you want to believe. Is there an issue there? And if it came to it at that point, then that's where the determination of do they have the right to do what they want to do under their lease may go to another forum. But you have the power and the expertise to determine the unitization question on the merits. Today is Hoodoo a respondent? Are their property rights, or may their property rights be affected? Was the December decision a final identical issue decision? Remember your finding. Okay, it's expected to be continuous. It doesn't mean it's conclusive. If we have evidence to show that it's not, that's a whole different area. And you have the right, again, you can have continuous jurisdiction over these matters to address that. Thank you.
Any questions for Hoodoo from the board?
So why didn't you respond in October or December?
Again, it was a pilot program that they were expecting at that point. And don't get confused, the hearing was in October, the board order was issued in
was in
December, so
December.
it's
Okay.
October that you're talking about here. It was a pilot program that talked about tar sands. As they talk about unitization and some of the other things in, we've discovered information that allows us to challenge it. And again, they opened the door by not including the unitization as part of that initial thing. If that had been included at that time, I would have a little harder time trying to argue collateral estoppel against it. But in this case, this is a different matter, a different issue, and you cannot apply collateral estoppel under the case law established in Utah.
Any other questions from the board? Two brief questions. I did warn you, I'm just still curious, have there been any conventional oil and gas drilling in this 2 square mile
My understanding,
area?
I don't know if it's in this area. My understanding was Tom Brown drilled something out there. I don't know if that was in what context or whatever, but that was an old situation. It's currently under the existing leases. Obviously, there is no current production on it right now.
I assume, based on the fact that you're here, that your client, or that it's felt that the 24-hour mobility test is not protective of.
That's correct. They
rights.
believe, their argument is a relative permeability test is the one to determine that. That is what it's done. And again, but that goes to the merits.
Okay.
Where your focus today is simply, is Hoodoo to be a respondent.
I know, but they are a little bit like that. We're trying.
I understand. But no, we disagree. We think a relative permeability test, and that's why we filed the Exhibit M rebuttal exhibit, using their data.
Okay.
Or the
thank
data
you.
they supplied, let me put it that way.
Any last questions from the board? Seeing none, back to the division for some insight to help us out.
Mr. Orland Wallace has some information to answer one of your questions, so I'd ask the board to recognize Orland Wallace to give you some information.
Please proceed.
Yes, I went out for an on-site in this area the other day, and there's two. We saw 2 dry hole markers. One of them was drilled by Shell way back in the day. I don't know the detail of what went on there, but I'm sure we could dig the well file and look at it if we need to. But there is also another, I show in this area, so that's in section 23. And then I show in section 22 in that area that there's another dry hole marker in that area. So just to clarify, there has been wells drilled in this area. There's one that's been drilled a little further north in Mazer. I had the opportunity with Schlumberger to go out and log that well, and it ended up to be a great water well. So, but that's all the information I have on that. But there is some wells that have been drilled in that area.
Thank you.
And the board has access to the Data Explorer that can look at these wells. But it's my understanding that we're here today to discuss just the motion to strike. The division is not taking a position on the motion to strike and whether Hoodoo should be a party to the unitization matter. The division does, once again, believe that the findings and conclusions that were final in the from the October hearing should not be challenged at this time, and they should stand as they were set in that December order. The division has nothing further.
Any questions for the division? Seeing none, I believe that draws an end to the testimony phase. I'm sure we need to consult together, so I believe we're going to go off the record and have a discussion, and we will be back as soon as we can. Thank you.
Thank you.
We are back on the record, and I would entertain a motion.
Mr. Chairman, I move the board to recognize Hoodoo as a proper party, withstanding as to Heavy Sweet Oil's request to unitize the subject lands. Under the condition, all facts within this board's December 8th, 2022 order be conclusively established regarding lands within the pilot project moving forward.
Second.
I'll second that.
Any last comments from any board members? Seeing none, all those in favor say aye.
Aye.
Let the record show that was unanimous. Heavy Sweet, could you please draft the necessary documents for board council review?
Certainly will do.
Thank you.
Thank you.
And that concludes this matter, and it is almost 12:15. I believe we should probably break for lunch now and then go through all the other caseload this afternoon, reconvening at 1 o'clock, if that works for everybody, and we are off the record. Thank you.
Sound check, 1, 2, sound. Hey, Paul, will you turn Oventive on 55 right? Paul, will you give me camera 3 on 55 right? Hey, Oventive, do you want to give us a sound check real quick, just so we'll be ready for the next one? Brett, can you hear me? Can't hear you yet. And Peter, it looks like you said something, but still can't hear you. It's okay. We'll do another sound check before we move on with you guys. We'll be live in 5, 4, 3, 2, 1.
Welcome back. We are back on the record. We are going to mix up the order of docketed items just a little bit here. We are moving to number 4 next, which is docket number 2023-026, cause number 130-20. In the matter of the request for agency action of WEM Operating LLC for an order partially vacating the board's order in dockets number 2019-001 and 2022-022, cause number 139-160 and 130-13, and 1, establishing 8 approximate 640-acre drilling units, and 2, establishing 4 approximately 1280-acre laydown overlapping drilling units for the production of oil, gas, and associated hydrocarbons from the lower Green River and Green River Wasatch formations. I will now ask for appearance of counsel. Yes.
Sorry. Brent Chicken, Steptoe and Johnson, PLLC, on behalf of WM Operating LLC.
Fred McDonald of Counsel with Lear & Lear on behalf of Respondent Wax Operating LLC.
Charles Lyons, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Thank you. Over to you, Mr. Chicken.
Thank you, Mr. Chair. I'm going to give a brief introduction, and there's going to be some housekeeping items in that introduction as well. I think all of the council involved is aware of these housekeeping items, but if there's any questions while I'm doing it. So I just want to kind of set the scene. At present, we've got these 8 governmental sections. They're identified as the subject lands, and they're currently governed by the 2 orders that we're asking for to partially vacate, 139-160 and 130-013. Really what this comes down to is 139-160 and 130-013. established 1,280 acre DSUs on these lands, allowing up to 12 stand-up long lateral horizontal wells in each DSU, 330 foot north-south heel-toe boundary setbacks, 560 foot east-west boundary setbacks, 330 foot inner well, and up to 8 vertical, directional, or short lateral wells in each one of those DSUs with very similar setbacks. Importantly, however, these two orders were done in February of 2019 and November of 2022, but no horizontal wells have been drilled on these lands. And so we only actually have one well in operation on these lands right now, and that's the Malesko 3405 DH well, which is a vertical well. And so from a practical standpoint, the horizontal well provisions of the prior orders, 139-160 and 130-013, have not kicked in yet because they have not been drilled. So the primary purpose of our RAA is to really reorient this area from north-south stand-up DSUs to east-west lay-down DSUs, reimpose the vertical and directional well spacing scheme that existed before the 139 and 139-160 and 130-013 orders. And I guess the easiest one to point you to there is the order from May of 2012, which is 139-08, and that's identified in the RAA, which had 640 acre spacing units with up to 4 vertical and directional wells. And really eschewing any spacing at this time for short lateral horizontal wells. And this is mostly driven by WM's recent acquisition of these lands, and their geology and engineering in their minds suggests a little bit different development pattern. To effect the same, we've got our RAA request partial vacations of those two orders, 139-160 and 130-013. Establish 8 640-acre DSUs with 4 vertical or directional wells in each, with those old school 660 boundary and 1320 interwell setbacks for those vertical and directional wells, and establishment of 4 laydown 1280s. And subject to some of my housekeeping items, in general, we are asking for 100-foot east-west heel-toe boundary setbacks and 330-foot north-south lateral setbacks. But that leads me to the 2 housekeeping items. The first housekeeping item discussed with some of the division and boards council is there are 2 typos in my RAA. I apologize for that in advance. On page 6, paragraph 4, and page 16, paragraph E, it references 8 vertical or directional wells. In both cases, that should be a 4. I've confirmed that with counsel for the board and the division, and it was agreed that we could make this oral amendment to change those without having to go through a whole bunch of stuff. It's literally a simple typo. And to make that clear, for the 640-acre DSUs that we're asking for, it's up to 4 vertical directional wells in those 640s. The 8 referenced in page 6, paragraph 4, and page 16, paragraph E should both be a 4. I would like to orally amend the RAA as to that point, subject to any objections either the board, the division, or Mr. McDonald and his client may have. And then the second housekeeping item is, as the board is aware, there were 2 responses filed to WM's RAA, timely filed on June 12th. The first one was filed by Oventiv, the second one by Uintawax Operating. Representatives of WEM and Oventiv were able to privately resolve their issues, and that resulted in a formal withdrawal of Oventiv's protest on 6/15/2023. Representatives of Uintawax and WEM and their respective counsel also resolved the issues raised in Uintawax Operating's response. But the way we're going to handle that, because we kind of ran out of time, is to essentially do the same exact thing. Sorry, that bumped up. And that is on the far western side of these 8 640-acre units covered by our RAA. we have sections 27 and 34. Right on the other side of those is the Uinta Wax operating lands, and so we directly abut each other. And so what I'm going to do now is I'm going to also orally amend the RAA so that as to the western boundary of sections 27 and 34, rather than the 100-foot heel-toe setback that is in our RAA, we are going to ask for 330 feet. That makes it basically mirror what is across the border there on the eastern side of 27 and 34. And this too was run by not only Mr. McDonald on behalf of Uinta Wax, but also counsel for the division and counsel for the board. We believe that since these both of these oral amendments, one of them being typographical and the other one is actually increasing the setback that we had asked for, rather than, we're getting further away from that line rather than getting closer, that this was probably the most appropriate way to do this, rather than making that small amendment and having to go and put the board and everybody through the re-notification process and all of that. And as a component of this, with this oral amendment, the part of the agreement with Uinta Wax is that, following my introduction here, that Uinta Wax will then orally withdraw its protest or its response to our RAA, and then when it is time to put together a draft order, assuming the board grants our RAA, that we will share that draft order with Mr. McDonald so that he can confirm in that order that sections 27 and 34, the heel-toe setback from that western boundary, is in fact going to be 330 feet, not 100 feet. And so I have a couple of other pieces and parts, but I think it's probably a good time to let the board and the other council involved here make any comments they want to on those two oral amendments of the RAA.
Mr. McDonald, any questions or concerns about the?
No, Mr. Chairman, and just for the record, since Mr. Chicken did put the agreement on the record, I will be, on behalf of Uinta Wax Operating LLC, withdrawing our objection to this, and the hearing can go forward as planned with those stipulations that Mr. Chicken just stated.
Thank you. Division?
The division doesn't have any objections to anything that just took place. I would just, for housekeeping, just like to, if this request is granted and this order is written up, that a lot of this is explained in footnote or however you want to do it, that it's just memorialized that way so it's clear for everyone.
Certainly, and there's the preamble to that order where we talk about who was here and who represented who. I will make sure that both of those protests are discussed and the resolution of both of those, and then Mr. McDonald will get an opportunity along with yourself and counsel for the board to look at that as well. So we're happy to do that. So, okay, was there any other input from division, board, council?
Nothing further from the division, sorry.
1 second. I think I'd like to maybe call for a vote on acceptance of the oral amendments. If I could have a motion on that.
Mr. Chairman, I move that we accept the amendments as stated.
Second.
All those in favor say aye.
Aye.
Aye. Let the record show that was unanimous. Thank you. Back to you, Mr. Chicken.
Okay, thank you. Appreciate that, everyone here. That made it, it was very important for us to have the hearing today, and so thank you to everyone that worked together to make that happen. We really appreciate it. Just in closing then, we're, based on the evidence and technical data that WEM is going to produce today to the board, we believe that the relief sought will protect correlative rights, prevent waste, minimize surface impacts, and allow maximum resource recovery. That evidence and technical data is going to be provided by Kevin Darcy, who is sitting to my left, which is WM Operating's Vice President of Land and Business Development. And then also behind me, we have Stephen Phillips, PhD. He is WEM Operating's Senior Geologist, and Dustin Treek, who is WEM Operating's Chief Operating Officer and Engineering Expert. In particular, as to the requested long lateral horizontal well setbacks, when we're talking about the heel-toe setbacks, we are asking for, except of course on that western side, 100-foot heel-toe setbacks. There are a number of orders where setbacks, heel-toe setbacks ranging from 100 to 135 feet, as the board is aware, have been approved. And I don't know if you want me to kind of list those, or if you want me to generally say, please take administrative notice of the board's existing orders where heel-toe, long lateral horizontal setbacks of 100 to 135 feet have been previously approved. And as Mr. Begley is nodding his head, there's about 10 of those orders. And so it helps us out a little bit here to not sit here and recite all of them.
I think we can so recognize those.
Thank you, Mr. Borden. And with that, I don't have any further introductory comments, and so I'd like to move to my first witness unless the board has any other questions for myself at this time.
Please proceed.
Okay. I am going to call my first witness, Kevin Darcy, sitting to my left. He's WAM Operating's Vice President of Land and Business Development. Can I ask that Mr. Darcy be sworn, please?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, thank you, Mr. Darcy. I'm going to put our table of comments up here, or table of contents up here for the time being. Have you testified before this body before, Mr. Darcy?
No.
Okay. Can you just give the board and other counsel here brief background of your education and your experience in the Uinta Basin so that they have a basis for your testimony today?
Sure. Attended Marion University and the University of Oklahoma for a business degree. Started working with Crescent Point Energy in 2014. I was with them until 2019 when they sold the asset to what is now Uinta Wax Finley. I've been with Wasatch Energy for just over a year, primarily focused on the Uinta Basin for nearly all of my career.
Okay. In terms of foundation, does anyone on the board have any other questions for Mr. Darcy? He's a fact witness today, so we're not seeking to qualify him as an expert. Okay. Thank you very much. With that, we'll move to the first exhibit, which is our Exhibit B. The first one is actually the table of contents. Exhibit B, Mr. Darcy, were all the exhibits you're going to discuss today prepared by you or under your supervision, direction, and control?
They were.
Okay, thank you. Can you please describe to us Exhibit B and what's being shown there?
This is a schematic of our high-level organizational chart. Wasatch Energy Management, Uinta 1, 2, 3, and 4 are individual funds that we manage and raise, and WEM Operating is the parent that we will be running all permitting through, spacing, and development for those entities.
Okay, and so this is just being provided to give the board an understanding of your corporate structure, and that WAM Operating is the proper party to be filing this application and making the request today.
Correct.
Okay. I'll move to Exhibit C.
We just wanted to show our team the experience within the basin. So our executive, primarily Liberty Pioneer, they've been in Utah for quite some time. We are based in Provo. And outside of that, between Newfield, Anadarko, Crescent Point, Finley, we have a very experienced team within the basin.
Okay. We'll move on to Exhibit D. If you could give us a breakdown of what we're showing here.
This is showing our position within the basin. The Wasatch Energy Management group has, I think we're up around 500 million in capital raised. I think we have another 60 million going out this week for additional funding. So upwards of about $500 million, closing in on about 600 million. We've got about 20,000 acres, and below you can kind of just see each fund, what it's doing for production, what its structure is, and where we're at.
Okay. And so, in this slide, along with the other two previous, is just really trying to set a baseline so that the board understands kind of generally where your areas are, what your experience is coming from, and what type of capital you're looking to deploy in the Uinta Basin.
Correct.
We'll move to Exhibit E, and if you could please describe what's depicted here.
We are showing our 4 laydown drilling and spacing units that we are requesting today. You'll notice that 25 and 30 and 36 and 31 are over a township line. The boundary shown in light green has the Antelope Creek unit below to the southeast, which is the large, roughly half a township area. I would say that we over-notified with DSUs to the north, but overall we definitely reached everybody we intended to or close to. So we had about a 97.5% success rate. We had 2 mailings that went out dealing with the undeliverables on the backside. So it's about 900 mineral owners, some surface owners, working interest and overrides that were all contacted.
And so when we're looking at this, everything both dark and light green, true and complete copies of the RAA were sent by WAM operating to all the leasehold working interest and unleased mineral owners in everything that's green, in all of the light and dark green on this map, correct?
Correct, via certified mail.
Okay. And then you're also aware that WAM operating filed a certificate of service with the board evidencing that as well?
Correct, yes.
Okay. And then WM is also aware that the board caused its notice of hearing to be sent to that same list of parties and to also be published in the Deseret News, the Salt Lake City Tribune, and the Uinta Basin Standard.
Yes.
Okay. And based on that testimony, in your layman's opinion, have the laws and Utah law and administrative procedure governing notice for the REA been complied with by WEM operating?
Yes, they have.
Okay. We'll move on to Exhibit F. If you can please describe what this is depicting.
This is a zoomed-in view of our subject DSUs. We have 27 and 26 in 4.4. 34 and 35 and 4.4. Those 2 DSUs in particular on the western side is the change that we referenced with UNOAX going to 330s off of that western boundary. 25 and 30, which is 4.4 and 4.3, 36 and 31, which is in 4.4 and 4.3. And on the eastern side, we will operate that DSU as well, but that is not in the order today or shown on this slide, just for reference.
And so the RAA here is requesting not only these 4 1280 laydowns, but it is also asking for the creation of underlying 640-acre DSUs with up to 4 vertical or directionals in each as well, correct?
Correct.
Okay, thank you. Exhibit G, if you could please give us a little bit of a breakdown of what's going on here, no pun intended, as to the ownership.
The ballpark, we have about 90% or greater working interest in these units. We own about 350 net acres as well. There's a tribal, state, and fee component making up about 84% for fee, 2% for state, and about 14% tribal.
Okay. And so that, and just to clarify, as you were mentioning before, that's a combination of primarily leasehold working interest, but also some raw mineral ownership in which you participate those minerals.
We own those minerals in perpetuity. We also own the lease on those minerals as well.
Okay. Same difference, okay. This is Exhibit H, and this is discussing, I believe this is the first well that has its permit waiting in the wings, correct?
Correct. This is submitted as a FIFI permit with the contingent on this spacing being approved before that permit can be approved. But we are actively trying to get out here to HBP, our leasehold. So we are trying to drill as soon as we can.
Okay, and so this Kudu 1320 would be the first well drilled from that cane pad?
Correct.
And that cane pad is located outside of the subject lands of the RAA, correct?
Correct.
Okay. And that gives us, also gives us a breakdown of were 25 and 30 approved, it would be a mixed tribal and fee unit, correct?
Correct.
Okay. We'll move on to Exhibit I, and I believe this discusses some of the offset orders, but if you could please describe where our lands are in relation to these other orders and the significance.
Sure. You'll notice the yellow dashed line around cause number 139160 and cause number 13013, which are the existing stand-up DSUs that we are in one order partially vacating and the other completely vacating. Is that correct?
They're both, I believe they're both a partial vacation.
Partial
but
vacations.
yes.
The green crosshatch 13012 is showing the recent 100-foot setback stand-up mix laydown UNOAX order. And then to the southeast, just showing that Antelope Creek order as well.
Okay, and you're abutting that, and then to the north, you also have the 130-07 order, correct?
Correct.
Okay. And then I guess is 130-10 also abuts you, but it's kind of split, yes?
Correct. It's
got another order running through it.
yeah. They did correct that.
Yes, it's been corrected.
They corrected that a few months ago, Barry and Ovintiv. 21402 was the existing Antelope Creek unit. It had lands that fell out, weren't developed, and so the unit contracted. So that baby blue has since contracted down, so it doesn't overlap.
Okay. And that unit was never in our subject lands anyway, in any event, correct?
No, never in our lands, just adjacent.
Okay. Exhibit J, this is the one well that's in existence on these 8/640s, correct?
Correct.
And that is operated by UNOAX?
Correct. UNOAX has wellbore only rights, and they operate that well. We own the 320 acres underneath the north half of that section.
Okay. And that well is currently producing?
Correct.
And the spacing for that well is currently on 40, it's on a 40-acre rule-based spacing, if you will? Or is it under, it's been drilled under one of those other orders?
I believe, I'm not sure. I need to confirm.
Well, I'm looking at the 40-acre spacing on the
Okay.
on the document, so
Okay.
I don't know if you believe that's correct, just confirm that.
Confirmed.
Okay. Exhibit K, I think this is why we didn't recite all of the heel-toe boundary 100 to 135 foot orders, because there's a lot of them, but if you can please discuss what's on this slide.
On the north side, I believe XCL is still on the docket today for 100-foot in the orange DSUs. That is an order that is both lay down and stand up, so it's very, as we'll get to in the technical case, very appropriate. UNOAX has a larger 100-foot heel toe setback position we just noted on the eastern and western side of the basin. Finley has also requested it and been approved in 4 South 1 East, Ovintiv quite a bit as well in the yellow. And in the purple, we're showing Javelin's orders that were approved with EP at 135. So kind of within that striking distance of 100 to 135.
Sure, and on this map, our subject lands are the blue highlighted 8 640s at the bottom, correct?
Correct.
And I think that is your last slide. I don't have any further questions for Mr. Darcy, but if the board or division does.
Division?
Division doesn't have any questions for this witness.
Board, any questions? Yes, Mr. Church.
Mr. Darcy, would you remind me again, is WEM an incorporated under Utah laws, or
We are, yes.
you're a Utah corporation?
Limited liability company, Mr. Church. Yeah. But Utah organized, yes.
No more questions from the board, it looks like.
Okay, Mr. Darcy, you are excused. The next witness I would like to call is Mr. Stephen Phillips, PhD. He is the senior geologist. If you want to stay standing, she's going to swear you in.
Do you swear, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Phillips, have you appeared or given testimony before the Utah Board of Oil and Gas previously?
I have not.
Okay. Yeah, there you go.
I have not.
So we'll be offering Mr. Phillips' testimony today as both a fact and an expert witness. And so if you could please give the board a brief history of your education, your work experience, and in particular your background and experience in the Uinta Basin so that they can evaluate your qualifications as an expert witness.
Absolutely. Yes, so I have a bachelor's and master's degree from BYU in geology. I also have a PhD from the University of Aberdeen, or King's College in Aberdeen, Scotland. Work there was funded by industry majors. I also have a postdoctoral fellowship at BYU, which was funded by ConocoPhillips. I have 5.5 years experience with Anadarko Petroleum Corporation, working strictly in the Uinta Basin. And then I have another 1.5 years of experience here with Wasatch Energy, also working in the Uinta Basin. My current role is a chiefly operations-based role, and I have contributed to drilling 14 horizontal wells and hundreds of directional wells in the Uinta Basin.
Based on Mr. Phillips' testimony, I would request that his testimony today be accepted as expert testimony, subject to any further voir dire by the board or the division.
Division, any concerns or objections?
No concerns or objections from the division.
Board? Seeing none, he's recognized.
Okay, thank you very much. With that, we'll move on to Exhibit L, and I'll ask you preliminarily, all the exhibits that you'll be discussing today and providing testimony on were prepared at your prepared by you or under your supervision, direction, or control.
Yes, that's right.
So we'll go to Exhibit L here, which is your type log of the Lower Green River and Wasatch. If you could please describe what's being depicted here, including the identification of the subject lands and discussion of the type log well.
You bet. Pretty standard slide, I think, that you've seen quite a few times before. What I'm showing here is just a map of portion of the basin, which shows the majority of the currently drilled and producing horizontal wells. But you do see there outlined in blue the subject DSUs that we're talking about today. And then up there in the north, there's a little yellow star, which represents the location of the type log, which is the Brotherson 111B4 well. I've included this type log because it should be somewhat familiar to the board, as it has been included in other
causes in the past. It also shows the proposed spacing interval and covers that full interval.
Okay. And you've noted down in the lower left-hand corner, please see also several other causes. My understanding is those are causes that are close to or adjacent to us, and that's the reason that you've mentioned them there?
The primary reason is to actually call out that this particular type log has been used in those causes.
Okay. Moving on, we'll go to Exhibit M, which talks about fracture azimuth. If you could please describe in detail what you've prepared for the board on this slide.
If you don't mind, could we do Exhibit U before this one?
Sure. And I don't know if the board is aware or not, but after discussions with the division, we filed a motion to file some supplemental exhibits. And because we didn't want to monkey wrench the whole thing, I might have to skip to the end to get to Exhibit U and then come back. So that's where I'm going. All right. This should be Exhibit U.
Yes.
Okay, if you could, and this includes, you also prepared this exhibit?
I did. Yeah.
Okay.
Yeah, I just kind of included this for the benefit of the board to kind of give a little bit of an introduction to some of the data that you're going to see in other exhibits. If I could just draw your attention to the image that's at the bottom of this slide. What you're looking at is essentially a cross-section of a wellbore. And there are a couple different types of structures that I just wanted to bring your attention to that form when you're drilling a well. And so one of those is borehole breakout, which forms in the compressive region of the wellbore. It's shown in that diagram as the red. And that typically forms perpendicular to SH max. SH max is just an abbreviation for maximum horizontal stress, which is, a key part of our argument today for changing these to laydowns. The other type of structure that forms when you're drilling wells are drilling-induced tensile fractures, and those form in the tensile region of the wellbore, which you can see in blue. And I've labeled SH max as blue also because those structures form parallel to SH max. And we use this kind of data to determine what the orientation of the wellbore should be. Ideally, you want to have your wellbores drilled perpendicular to SH max so that any of your fractures that you initiate later will follow that fracture pattern. One last kind of comment for this slide would be when you have something called anisotropy, which is just a fancy word that means preferred orientation, when you form those fractures, they're all going to want to go in a similar direction. What that does is it causes your drainage of the reservoir to be elliptical in nature rather than circular. So when you see Mr. Trike's exhibits later on, you'll know why we've modeled those that way.
Okay, and so you're okay now to go back?
Yeah.
Okay. Yeah. Okay, so now we're on Exhibit M with that brief introduction, and I'm sure everybody understands from the cross-section that picture he's showing you is kind of you're down in the dirt looking long ways through the wellbore, in case, because that wasn't immediately clear to me when I looked at it, but after I was explained it, I understood it. So now with that kind of background, if you can please describe what a fracture azimuth is. I'm sure the board's very well aware, as is the division, but explain that and explain what we're showing here.
Okay. Yeah, so both of those types of data, drilling-induced tensile fractures and borehole breakout, can be used to estimate SH max. And it's pretty standard practice. And so now I'm showing you actual data from near the subject lands here. On the map, which I'll draw your attention to first, you can see these symbols that are red circles with like a slash line between them, or through the middle of them. Those are what I'll call our stress symbols, and that slash is in the orientation of SH max. So near the acreage and all over the western side of the map, you can see that SH max is very demonstrably north-south in orientation. The other things I would like to draw your attention to, actually, before I go on, the two little rose diagrams there in the upper right-hand corner, I'm going to show them to you on a separate exhibit, so you can ignore those for the moment. We'll just look at the map. But I have included 6 different wells on this map, and I've colored 4 of them green and 2 of them blue. The green wells are in a lay-down orientation, and the blue wells are in a stand-up orientation. Some of the data that we'll be looking at comes from this well that's labeled Alice, and so we'll see that on the next exhibit. The reason I bring your attention to these wells is that we're not asking for a proof of concept here. We have drilled lay-down wells and we have drilled stand-up wells, and we know which ones are better. And so what we're hoping to do going forward is drill these wells in the proper orientation, which is a laydown. Mr. Trike will show some data to this effect later on, so you can see the difference between those wells in their performance. And I think that's all I have for this slide.
And just so that I'm keeping myself straight, the idea is that when you're talking about those little red circles, you want to intersect that line perpendicularly rather than parallel, correct? You want to get as close to going straight into that line, correct?
That's exactly right. Okay. You want to be perpendicular to the SH max trend, which in this area is north-south.
Okay.
So we want to drill our wells east-west.
So we'll move to Exhibit N, and this discusses our setbacks and the fracture orientations. If you could please go into more detail than that.
Sir, we'll move to Exhibit V and then W, and then it'll be Mr. Trike for this.
Okay, so this is, okay. Let me go down to V.
Apologies.
There's your promised larger maps.
Exactly. Okay, what you're looking at here on Exhibit V, I have showed 2 different what we call rose diagrams. You can read them just like a compass, so the top part of each of those diagrams would be north, and then the bottom would be south, and so on. The rose diagram on the left is showing drilling-induced tensile fractures. And so if you recall, those are formed parallel to SH max. And so what you see here is essentially a north-south trend. It's just a little off of north, but it's very clearly north-south. And that is acquired in the vertical portion of the wellbore. In addition to that, and I should say that is also where we get our estimation of SH max. But in addition to that, we can also measure natural fractures in the lateral portion of the wellbore. And so that's what you're seeing on the rose diagram on the right. And it's showing that over 1,000 natural fractures were observed, and they all have this same kind of north-south orientation. There are some other fracture sets that have different orientations, but it's overwhelmingly north-south to the tune of 80% of those observed fractures. There's a little bit of an issue when you look at natural fractures. If they're oriented north-south and your lateral is also oriented north-south, you're actually going to undersample those north-south fractures because you're not going to be crossing them. You're going to be drilling alongside them, as it were. And so you can model how many natural fractures you should expect to have if that wellbore bias was removed. And so they've done that, and you can see there that the number goes way up. 2,876 is what the table says. But the point is that 80 to 90% of the fractures are north-south oriented. And that's what's the point I'm trying to drive home from this slide, is that we definitely want to be perpendicular. And so we need to be drilling these wells as laydowns.
Okay. And then you said you want to go to
just one more down.
W?
Yes. This will be my last exhibit. And so I've just created this, it's a little larger view, so you can see more of the basin here. If I'll just draw your attention to the west side of this map for a moment, you can see some of those symbols that we've already discussed and how the slashes in those circles are pretty much all north-south on the west side of the basin, overwhelmingly so. If you look on the east side of the map, you can see that that orientation is more east-west, kind of northwest, southeast oriented, and very consistent on both sides, right? We have what we call a transition zone in between there, and I've shown that with this little red dashed line. And we believe that transition zone to be east of the DSUs that we're discussing today. And so I guess one really simple way to put it would be if you're on the west side of that red dashed line, you really want your wells to be laydowns in orientation. If you're on the east side of that line, you really want your wells to be in stand-up orientation. If you're in the transition zone, it really matters a little bit less. And so you'll see a lot of this kind of data later when XCL presents.
Okay, so you have no further comments for Exhibit
Nope.
W? I do not have any other further questions or examination for Mr. Phillips, but we'll open that up to the division and board to ask questions. And if there's a slide you need reference, just let me know. I can hop around.
Division?
Yeah, if it'd be all right, Mr. Borden, to have Peter Pankey, geologist with the division, ask this witness some questions.
Please proceed.
Mr. Phillips, this slide is perfect. I'm just wondering why these were originally planned as stand-ups.
Yeah, that's a fantastic question. Originally, the concept was that you would drill stand-ups to kind of link up fault blocks in the Duchesne fault zone. And that's why we drilled the Phillip and the Alice in that orientation. Unfortunately, it was the wrong call. We did link up those fault blocks, but our fractures are not propagating in the east-west direction like we had hoped. It's a good question.
And can you see the Duchesne fault on this map?
Thanks. Yes, they're the red lines. I should mention, we don't have a deep reverse fault line that I can put on this map. So what you're seeing are the surface expressions of normal faults. So that fault zone is going to get narrower and narrower as you move deeper into the formation. So you shouldn't expect to see such a wide zone at depth. But there will be faults, and that's just something we have to deal with. But we definitely have proof of concept now that the idea of drilling north-south and connecting up those blocks is not nearly as important as it is to be perpendicular to the modern-day stress field.
That's all my questions.
Thank you.
No further questions from the division. Thanks.
Okay. Board, any questions? Yes, Mr. Moon.
So you make a good argument that these should be lay down, but your argument apparently didn't work with you into wax. Because if they would have went lay down, you could have agreed to the 100-foot heel toe. What happened?
Yeah, you're absolutely right. I think that I can't speak for wax, but if I had to guess, I would say that their current understanding is that they still like this idea of connecting up those fault blocks or being perpendicular to that fault zone. I also know that some of their argument hinges upon the idea that there may be equal stresses in this area. The problem with that is that you can't have equal stresses in an area and then proceed to model your drainage as an anisotropic drainage pattern. The Uinta Basin actually is one of the most anisotropic places that I know of. And so we're definitely looking at a situation where, at worst, you might have, say, a 45-degree angle on your fractures. And if you did, if it was the worst-case scenario, which it isn't, you'd be free to choose stand-up or lay down because it doesn't matter at that point. We believe that that kind of an angle, a 45-degree angle, doesn't exist until you get east far enough that you see that red dashed line. So well east of our acreage position.
Have they drilled some wells in the drilling units close to there, similar to the Phillip and Alice, and they still feel like stand-ups are the way to go, huh?
Good question. They do have two horizontals. They're short, super short horizontals, and they're kind of to the west. Actually, on this map, if you look, there's two little green kind of plus symbols. Those would be their horizontals that are nearby. And much of their data would be based on those, I would expect.
Okay. All right. Thank you.
Yep.
Mr. Church.
Mr. Phillips, I'm trying to understand your symbolism there, the Duchesne Fault Zone. When you go on the east side of that transition boundary, what are the northeast-southwest straight red lines?
Good question. Those are wells that we're currently drilling in the Greater Monument Butte unit. And it's just there to illustrate that you want to be perpendicular to that stress. So over in that part of the field, you can see that our orientation of our well bores is perpendicular to those green dashed lines.
So are the stress directions, the stresses that exist there subsequent to the formation of the Duchesne Fault Zone? Why do we have a disparity between the trend of this fault zone and this maximum stress directions?
Yeah, fantastic question. The stress that you see in the eastern side of the basin is much older. And so what we're seeing now in the modern day is that the western side of this basin is experiencing extension from the basin and range extension. And so it's different. And that's why there's a transition zone. So the Duchesne Fault Zone, as it goes west across those green lines that are vertical, you're basically seeing a relict structure. In fact, it hasn't moved in millions of years. It's a very good question. Yeah.
Thank you.
Seeing no more questions, back to you, Mr. Chicken.
Unless Mr. Phillips has anything else to add, my last question for him would be, based on your testimony and exhibits today, and the questions and answers asked by the board and the division, do you believe that the WAM Operating's RAA, the request sought, if granted, will protect correlative rights, prevent waste, minimize surface impact, and maximize resource recovery?
I do.
Okay. I have no further questions for Mr. Phillips. I would call my third and last witness, Mr. Dustin Treek. Mr. Treek is WAM Operating's Chief Operating Officer, and might as well stay standing because the next thing I'm going to ask is for you to be sworn in.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
And Mr. Treek, have you appeared and testified before the Utah Board of Oil and Gas in the past?
Yes, sir.
And when you have appeared in the past, were you qualified, or was your testimony qualified as that of an expert witness?
Yes, sir.
Subject to the board requesting any voir dire or further background information, I'd like to ask that Mr. Treek's testimony today be treated as expert testimony in engineering. Sorry.
Division?
No objections from the division.
Board? Seeing no objections, he's so recognized.
Great, thank you. And we'll start off with Exhibit N, or did you want to start with one of your newer ones?
No,
Okay.
N is perfect.
And just as a housekeeping matter, all of the exhibits that you'll be discussing and giving testimony on today were prepared by you under your supervision, direction, and control, correct?
Yes.
Okay. With that, if you could please enlighten us as to what Exhibit N tells us about lay-down heel-toe setbacks.
Yes. So you're looking at an illustration of our fracture geometry. I'm showing it here with the 100-foot heel-toe setbacks. For our fracture geometry, we're using a 252-foot fracture half-length. If you notice, there's a table in the bottom right. We feel like this is a very conservative approach to fracture half-length. I've included some offset data from other operators and dockets that include what they're using for half-lengths. We feel like 252 feet is very generous. We're also showing this with a 15-degree frac azimuth.
we feel like this is a conservative estimate on that front as well. Our focus is to maximize drainage while protecting correlative rights. So the 100-foot heel-toe setbacks give us maximum flexibility and the ability to drain as much as possible without encroaching on the section line.
Okay, we'll move from Exhibit N to Exhibit O, which is also showing your lateral setbacks, which in this case would be the setbacks from the north and south lines.
Yes, very similar illustration, just slightly different, showing the 330-foot distance from the wellbore to the section line above it, so the north-south distance. And you can see here, we still have a very generous cushion to the section line in this case.
Okay. Moving on to Exhibit P for looking at offset production. If you could please describe what's depicted there.
So the data at our disposal that is just offset our cause area to the north, we have recent horizontal results that it is a clear indication that these DSUs should be spaced in the laydown fashion. I've got two sets of wells and two components to this slide. On the left part of the slide, this is a cumulative oil chart over time, normalized. I've got two sets of wells, the green wells, which are the laydown wells that Mr. Phillips mentioned in his slides, and then the blue wells, which are the stand-ups just north of the cause area. I've also included a locator map. You can see they're just above, outlined in purple, our cause area today. We see a 60% uplift in production from laydown to stand-up. These are similar completions. They're modern completions from the same operator, same time frame, same target formation. This isn't a typical degradation we would expect to see DSU to DSU. For us, this is a clear indicator that these need to be laydowns in order to drill the best wells possible.
And we'll move on to Exhibit Q.
Let's go to drainage.
Okay. We are going to instead move to Exhibit X.
Perfect. Utilizing the Hale and Evers drainage calculations, we show a negligible impact on adjacent lands within 5 years of development. We believe we're looking at this very conservatively with the longer fracture half lengths and the 15-degree frac azimuth. For clarification, we did utilize reservoir inputs for this model from offset UNOAC's cause number 13012. This is the cause number right next door. That's about it.
Okay, and the chart at the bottom is showing your assumptions?
Yes, sir. So you have the inputs in yellow and a description of the variables, and then the table to the right with the time and the drainages and the footages for both the major and minor ellipses of the drainage ellipse.
Okay, and so even using this data, you still feel that your 330-foot north-south and 100-foot east-west, except in 27 and 34 western boundary, are still conservative?
Yes, sir.
Okay. With that, we'll go back up to Q. And these are your economics, and if you could please describe what's depicted here.
This is a comparison between a 330-foot heel-toe setback well and a 100-foot heel-toe setback well. So we can assume a recovery per foot and take that recovery and multiply it by an oil price. In this case, if we can maximize our lateral lengths, in this case, we would be returning at a $70 price environment an additional $2.5 million of revenue per well. The enhanced setbacks allow for maximum operational flexibility for us, along with returning the most revenue possible.
Okay, and so if I'm understanding this correctly, going from a 560-foot lateral setback to 330 and going from 330 to 100 is going to result in the additional revenue and the additional production and severance taxes seen here?
Yes, because of the recovery.
Sure, because there's just more lateral to pull it in.
Yep.
And the same thing with those two charts at the bottom, correct? That these are you're discussing the interwell setbacks, correct? And if you have smaller interwell setbacks, you're showing higher oil recovery.
Yeah, very simple graphic, just and also to illustrate the operational flexibility. It's great when we can maximize the footprint we can operate in within a DSU.
Okay. And I believe that is Mr. Treek's last slide, and so I guess my only follow-up question is, based on your evidence and slides and testimony given today, do you believe the relief requested in WM Operating's RAA is likely to protect correlative rights, prevent waste, minimize surface impacts, and maximize resource recovery?
Yes, sir.
Okay. I have no further questions for Mr. Treek. I'd turn it over to the division and/or board for questions, comments, et cetera.
Division.
Thanks. I have one question. Could you go back to Exhibit N? I just wanted to clarify.
N?
N as in no, yeah.
There you go.
Thank you. I just wanted to clarify, I heard you referenced a table in the bottom right corner. However, in the exhibit here, I didn't see one. I just wanted to clarify that or point that out if that was something that was pertinent or relevant to your testimony, if that needed to be amended, because I don't see that in this exhibit.
Yeah, so I apologize. I'm looking at the table on this presentation, and it wasn't included, but it's a list of operators and offset dockets and the half lengths that they reference.
Okay. I just want to point that out, if that's something that maybe the board, if you want to submit an amended one, if that's pertinent to what you need to get
Yes,
across
and-
today. If not, if it's not a big deal. I
and
just
to
wanted
be-
to point that out for clarification.
No, thank you, and I actually think that's important information. You know, I think what we could do today is, well, no, we're just gonna give this to you to look at, and if you can give it to the board to look at, and then I will submit a request to amend exhibits N and O so that you have the ones with this. I don't know why that didn't end up in there, but it didn't, but I think you should look at them, and I think you should take a look. Now, I think it's good information. It's very comparative. So if we can give you a minute to look at that, and then you can give it to Mr. Moon to pass down as well. But we will reproduce that in our exhibits and get those that little chart in there.
Okay, thank you. I personally don't have any further questions, but if it's okay, Director Baza may like to ask a question of this witness.
Of course.
Thank you. My first question was very similar. As I'm looking at the table that you provided here, they range from half lengths of 110 feet, I'm assuming, up to 252. So the modeling that you're doing is showing a 252
Yes, sir.
foot half length?
Yes, sir.
Okay.
Yep.
And you feel that's reasonable? Because it looks like the average of those numbers is more like 181.
I do think it's reasonable, and it's a conservative approach. If we got better data, we could definitely shorten it down, but our goal is to always approach this conservatively first.
And you'll have to excuse me, I only recently became involved in looking at some of this stuff. But I wanted to clarify, so your request today is for 2 different sizes of drilling units? Is that correct? One for vertical and directional, and one for horizontal?
Yes, we have 640s for vertical and directional with no short laterals requested, and that's 8 640s, and then 4 1280s lay down just for long lateral with 100-foot heel toe, 330 north-south, and then accepting that far western one where it won't be 100, it'll be 330 by today's amendment.
So on the areas we're looking at, the 100-foot setback is on the north and south boundaries?
Yeah, so I'm gonna go back to one of these to show you a better picture of just this. So the 100-foot setback are gonna be on the east and west set right here. So functionally, what this means is this section line has got 100-foot heel toe. This section line has got 100-foot heel toe, but after today's amendment, this section line has 330-foot heel toe.
Okay, great. Seemed like there was one more thing I was going to ask. Sorry, I didn't write it down.
No, take your time. Wait, you were kind of thrown into the mix here.
Oh, yeah, I remember now. So no wells have actually been drilled within the proposed area for spacing, right?
No horizontals.
No horizontals. There is vertical well?
There's one vertical well.
One vertical
The Malesko.
well, okay.
And that is this, no,
It's hiding.
where's the Malesko? Sorry. I just saw it. There it is.
Yeah.
There it is, Mr.
Section
Boswell.
34.
It's in
And-
34, yep.
Is that well contributing to the properties that you're inputting on the Hale and Evers?
It is not. We don't operate that well. We don't have the data for it. If it was a useful data point, we absolutely would have used it.
Okay. So in terms of these properties, are they determined by analogy to?
It's, we are utilizing the offset cause areas from north and west of us, and mainly for the reservoir inputs, it's directly to the west. So the cause area for 28 and 33, which we share that section line with UNWACS, it's the reservoir inputs from their docket and technical work.
Okay, I understand. Thank you very much.
With that, no further questions from the division.
Thank you. Board, any questions? Yes.
So I see the diagram that you have here on Exhibit Q. So with the sectional setbacks, you're pointing out that in one you're able to drill 4 wells, and in the other one you're able to drill 5. So what are your interwell setbacks?
Depends. So currently, we're drilling in an area pretty close to this. It's just east, and we're using a 1,200-foot lateral-to-lateral setback. The diagram is simple. It doesn't necessarily mean we could go to 5, but it gives us the opportunity in the event that, hey, oil prices are higher and we can downspace and gather more resource, and we could potentially add more sticks per DSU. And by sticks, I mean wells.
Okay, so the difference, the additional barrels that you say that you can recover here, that was attributed to the 5th well, or?
No, it's attributed to the heel toe, to the actual lateral
the
length
section
being
line.
longer. Yes. I would say the diagrams more so are pointing to the fact we have more operational flexibility.
Thank you.
Yes, Mr. Moon.
So Steve's question makes me think of another question that I often have. So if your fracture half length is 250 or so, that means, doesn't that mean that you could put interwell setbacks at around 500, 550 and get 7 or 8 in a DSU in one horizon?
We absolutely could, but there's going to be trade-offs. Most likely, we're going to see degradation between the wells when they're tightly spaced like that. And really, commodity price could drive a lot of that conversation and well results. If we're in a very high price environment, we are more likely to downspace and add inventory. In a $68 price environment like we're at today, we're going to be more conservative, keep the spacing wider, and have our wells be more productive on a per foot basis.
Okay.
Another question I have then, you're not looking at wine rack type development, upper horizon, lower horizon? Or-
We have. Right now, our bread and butter is the Uteland Butte formation. It's operationally extremely friendly. We're drilling 12-day horizontal wells that are monobore. There are other targets in this basin that's just impossible. So the Uteland Butte, from a productivity per foot, is fantastic, and operationally is very friendly. That's our focus right now. Will we add other benches and targets down the road? Yes. We just, in terms of getting out here and getting this HBP'd and taking the low-hanging fruit first, we're going to target the Uteland Butte.
So even within the Uteland Butte, you're saying one horizontal well per
There is,
space in there?
the Uteland Butte is interesting. A lot of folks are micro-staggering within it. They'll drill the B or the C or the D benches or different target zones. In my opinion, we like to focus on drilling efficiencies. And so it's not so much, we can't peg certain well results to one particular part of the Uteland Butte. We just focus on what drills and completes the best. Because generally speaking, the wells produce very similarly in the Uteland Butte.
And Board Member Church, the RAA, to go to your question fully answered, does provide for no interwell setbacks on stacked wells, but those stacked wells got to be 100-foot vertically from each other, similar to other long lateral development plans that the commission or the board's approved. So it's there if they want it.
Seeing no other questions, back to you, Mr. Chicken.
Well, that's all of my witnesses. I don't have any further questions other than to ask the board, subject to anyone's objections or comments, to admit Exhibits A through X that were presented today, and to respectfully request the board to grant the relief sought in WAM Operating's RAA, subject to the two oral amendments adopted by the board a little bit earlier, and the approval of the draft order by council for the board, division, and UNTOX Operating.
Division, any concerns about entering those exhibits?
The only thing I would mention is, no objection to the exhibits as presented today, but you'd like to amend those.
Yes, we
those
will
other
amend those.
exhibits
Sorry,
to
I forgot to add that. I've got it written down though, so it will happen. And I will get that done before, hopefully before the draft order, or concurrently with it, which would be in early next week.
Board, any concerns? No? All right, so exhibits A through X are so admitted with amended exhibits N and O, I believe.
That's correct.
That's good.
And Mr. Board, if appropriate, may I ask for a 5-minute recess to discuss with the division so that we can put together a recommendation for the board on this matter?
Okay.
Okay, thank you. Okay, thanks, I appreciate that. So Director Baza has prepared a recommendation that he would like to make to the board in this matter.
Thank you, and members of the board. Just so that you know, we have conferred with the WEM people, and I think we'd like to support what they're asking for. We very much feel that orderly development is the proper thing to do, and that we want to ensure that some of the calculations that they're presenting to you today are validated over time, because obviously they need to drill some of these lateral wells to get some of the data that they would obtain to in order to validate the numbers they suggested to you today. So what we'd like to suggest is that the board approve what they're asking for, but additionally in the board order indicate that after they drill the wells or wells that they're hoping to drill, that they would provide us after some appropriate amount of time, and they would obtain the year of confidentiality by reporting back to the division, only to the division, not in a public meeting, but provide us with some validation of the reservoir properties that they're utilizing in their calculations, and just indicating that some of their proposed numbers are correct, and we would discuss that with them and have a technical meeting, whatever needs to happen, but they would still have the year of confidentiality after production to ensure that that data is not disseminated. So that's what we would say is we support what they're doing and would recommend that we go forward in that matter.
Thank you. Anything else from the division?
That's it. Unless you have any questions to clarify any of that statement or what the division is asking, we're good.
Any questions? Mr. Church?
Well, with that, I'd like to ask WEM, is your intention to come out and drill a well before you go in and drill multiple wells from the same pad?
Our intention is to drill 5 to 6 wells this year. We've got expirations that we need to drill and hold the acreage, so our intention is to drill 5 horizontals in the next 12 months on the acreage.
Okay, essentially with one rig that you'll have contracted and just move one to the other?
Yes, sir. Yep. We currently use H&P 257. It's on our scout project in the JV, and so we have it contracted and we'll utilize it, or maybe potentially more rigs down the road. But yes, we've got the rig and just need the permits and spaced. We're going to go.
Okay, and then Director Baza, I assume that information you will also share with the board. We don't count into that 1 year confidentiality.
We'll have to talk that out.
Okay.
I know that they're very concerned about maintaining confidentiality of the data, as we are. So we would certainly maybe report back to you in a summary fashion whether we've agreed with the numbers they've provided.
Okay, thank you.
And to confirm, we're happy to do this, and I'll make sure, I'll work with Mr. Begley and Ms. Harris to hammer out language that's acceptable to all the parties here so that we can maintain, I mean, we want to tell you what we're doing, we just don't want the universe knowing about it quite yet. And that's really all it comes down to. We love showing people our toys, just not everybody.
Okay, thank you, Mr. Chicken, and I assume WM and the division, any last statements or thoughts before, oh, yes, Mr. Moon.
So remind me what the conflict was with Ovintiv and how that was resolved.
So the conflict with Ovintiv was a very similar one because obviously this was all stand-up and we're moving to lay down. And so now we've got what used to be heel toes up against each other becoming heels and laterals. And so we entered, they only had a concern, and let me scroll down to this so you can see where the area is. Their only concern was in 25 and 30, and their only concern was on the very north line of that. So we entered into a private agreement that that discusses this well right here, and this the Kudu well. Can you guys see my my screen, I'm sorry, no, these are all black. There we go. But we entered into an agreement with them that concerns that well or whatever well would be drilled furthest north in 25 and 30. And we resolved the issue with that. And the main thrust of that order is, or of that agreement, it's also a covenant that runs with the land. It's been recorded in the real property records in both of those, because we're straddling that line right there. But that's how the Oventive matter was resolved and resulted in a withdrawal.
So was there an adjustment to the setback then?
Yes, there was an agreement to adjust that, not because they believed us or we believed them necessarily, but because the easiest way to resolve this was to, make that adjustment so that we had an agreement on that matter, rather than fighting it out and taking more of the party's time, the board's time, the division's time. It just made a lot of sense. I mean, it's a 2-page agreement. It just says whatever well gets drilled there, we're going to agree to stay a little bit further away from that line.
Okay. Any other questions from the board? So I would entertain a motion unless anyone feels strongly that we need to go into consultation.
I move we approve the request for agency action subject to the qualifications made by the division in terms of the information that they require.
I second.
All those in favor say aye. Aye. Let the record show that was unanimous. Mr. Chicken, could you prepare the necessary documentation?
Absolutely, along with the amended exhibits N and O. Yes.
And of course, incorporating those oral amendments which you made at the start of the process.
Yes, I will lay it all out in detail so that anybody reading that order knows what happened today.
Perfect, thank you.
Thank you.
All right, I believe we may be ready to go back to item number 3. Excellent.
Oventive, can we get a sound check from you?
Yeah, this is Peter Burns with Oventive, sound check.
Peter, hear you loud and clear.
Brett Allison with Oventive, sound check.
Brett, we hear you even louder. Thank you.
We're 1/3 of the way done.
Monumental day.
I know. I'm already so tired.
This last case is really interesting. There's obviously a difference of opinion in the operators.
Yeah.
And their case
Anyway,
leaves
they
a
were all
little
in
bit.
production within a month. No, they just really thought that they needed to intersect the Duchesne Fault, and they thought they would get more production out of that Duchesne Fault versus all the natural fractures. But really, that's one point versus the whole well bore. And so they were pretty worried when they first got Philip and Alice.
Oh, yeah.
They just got water for like a week. And usually you get flowback. Well, it was the flowback from the frac. Usually you get some oil with it.
Yeah.
And they're like, thought maybe they'd blown out in the fall. But it was mostly that frac water, not just salt water.
Oh, good.
But they were worried.
I imagine.
So, because Wasatch actually fully funded those two, Alice and Philip.
Oh, yeah.
And, got a little more back. How would they come?
I think it's so interesting saying they're going to drill 6 of these huge wells this year. Remember when one vertical was
All right, are we ready to begin?
We are ready.
Okay. Next item is docket number 2023-025, cause number 132-18, in the matter of the request for agency action of Oventive USA, Inc. for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the Brothers Utah 13-10 4-2-16-21-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations. I will now ask for appearance of counsel.
Thank you, Chairman Borden. Mitch Mayo of Lear & Lear on behalf of Oventive USA, Inc.
Charles Lyons, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Over to you, Mr. Mayo.
Thank you, Chairman. Again, Mitch Mayo on behalf of Oventive USA, Inc. here today. The witnesses are appearing remotely by order of the board. With me today are Mr. Peter Burns. If you could raise your hand, Peter. Perfect. Senior Land Negotiator for Oventive, and Mr. Brett Allison. Can you raise your hand? Perfect. Reservoir Development Engineer for Uinta Basin. As I said, they are appearing electronically today. It's quite obvious. And based on informal feedback from the division, although witnesses appearing remotely have in the past been in a conference room together, it was suggested that we try this and see if this provides a little better feedback. So if there are any questions or concerns, please let us know. Also, because they're remote, I have my phone on. It's on silent, but if you hear a ding, I apologize, and thank you for the understanding in advance. Before we begin, could we please have the two witnesses sworn in? And could you guys stand up for this, or raise your hands, or what's the appropriate?
Just raise your right hand is fine. I'll swear you both at the same time. Gentlemen, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
The resumes of both these witnesses have been submitted as Exhibit A, and if asked separately, they would verify the contents as true and accurate. Both of these witnesses have appeared before the board on numerous occasions. Mr. Burns was admitted as an expert in petroleum land management in prior hearings, most recently in cause numbers 13210 and 13215. Similarly, Mr. Allison has been recognized as a board, as an expert by this board, as an expert in reservoir engineering, including last month in cause number 13217. With presumed stipulation from the division, I would move to or ask that these witnesses be recognized as experts in their respective fields for this cause.
Division, any concerns?
No concerns or objections from the division.
Board? Seeing none, they are so recognized.
Thank you for that. Also, as is standard practice, I'll be moving for admission of the exhibits at the end of my presentation in chief. A brief summary of this case. This matter is a straightforward compulsory pooling of a drilling unit established for Lower Green River Wasatch production, as Chairman Borden stated, from Section 16, 21, and 28 in Township 4 South to West, which is located in Duchesne County and may be referred to here as the subject unit. The subject unit was established by board order in 2021 in cause number 130-09. A true and correct copy of that order was submitted as Petitioner's Exhibit B. Pertinent to this hearing, the 130-09 order expressly authorizes the drilling and completion of long lateral wells, including the Brothers Well. At the time of filing the REA in this cause, there were 3 existing vertical and directional wells producing from the subject unit. The 130-09 order expressly provides production allocation from any existing wells on the subject unit, converts to the 3-sectional drilling unit basis, effective as of the first day of the month following first production of the first long lateral horizontal well. In accordance with the 130-09 order, an APD is approved by the division and the BIA. Oventive drilled the Brothers Well, which we may alternately call, the Brothers UT 13-10 4-2-16-21-1H well, which we may call the Brothers Well or the subject well. The Brothers Well's date of first production, as I said, was May 9th, 2022, resulting in the conversion of production allocation of any existing wells to the sectional basis, 16, 21, and 28, as of June 1st, 2022. There are several owners of oil and gas interests in these units that have either refused or failed to lease or otherwise voluntarily pool in this unit. Most of them you have seen in prior hearings. They are Kent Dukes, Mary Ellen Slemiker-Benyon, Scott Dukes, Shelley Smith, FKA Shelley No, Kate S. Fowler Markham, Leland Woodrow Noble Jr., Slover Minerals LP, and Tracy Lee Markham Sherrill. One quick correction, there was an additional party named in the request, Amy Eibach. She has since leased to Oventive, has reached out. So she is being removed here today, and Mr. Burns will address that in his testimony. Each of these identified owners being pooled here today received notice of the request at their last known address of record, where an address was available, and none have objected to the pooling or otherwise responded. Ms. Eibach did receive notice and reached out and has leased her interest. Aside from that, there hasn't been any discussions. In addition to receiving mailed notice of the REA, two of these mineral owners received published notice, Mary Ellen Slimaker Benyon and Leland Woodrow Noble Jr. Oventive is convinced of the accuracy of these addresses. However, these two parties failed or refused to pick up the mail that was delivered, and out of an abundance of caution, they were included in the published notice today. Accordingly, Oventive seeks the compulsory pooling of the parties listed here, but also identified on page 2 of the request for agency action, with the exception of Miss Amy Eibach. In addition, some of the fee leases were granted by parties claiming by, through, or under certain estates of deceased parties, as identified in the request. Because of a lack of confirmatory probate proceedings on those parties have been included in this request out of an abundance of caution as well. They may be referred to, anyone claiming by, through, or under these states will likely be referred to as unknowns in this hearing. Pursuant to order of the board entered on May 17th in this cause, a notice of opportunity to participate, as I mentioned, naming each of the unknowns, and Ms. Slimaker Benyon and Mr. Noble Jr. was published in the Uinta Basin Standard for 2 consecutive weeks. Proof of this publication was filed separately as Petitioner's Exhibit R. As I said, no party has responded or otherwise tendered his or her share of the costs, except for Ms. Eibach, and Oventive therefore seeks to have these unknown parties compulsory pooled and declared as non-consenting owners. As to the non-consenting owners, Oventive asks for imposition of a 300% risk compensation award, imposition of the terms of a JOA this board is well familiar with by now, and during the recoupment period, the unleased non-consenting owners should be awarded an 18.511769% acreage-weighted average landowner's royalty. The board has jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations, 649.2.8a and 649.2.9a. In addition to the published notice of opportunity to participate mentioned earlier, notice of the filing of the RA and of this hearing was published in the Deseret News on June 2nd, the Salt Lake Tribune on June 4th, and the Uinta Basin Standard on June 5th. On June 21st, the division filed a response and notice of non-opposition to the request for agency action in this cause, generally supporting the requests at issue today. As I stated, no other responses were filed, and there have been no objections to date. As none of the alleged non-consenting parties have responded, we'd be moving for default of those parties under R641-104-150 and R641-108-400. And with that, if there's nothing further, I'll begin with my examination of Mr. Burns. Mr. Burns, can you, again, raise your hand in case anyone didn't see who you were? And could you please state your name and business address for the record?
Yes, Peter Burns, and Oventive's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay, and can you please state your position and general responsibilities as they relate to this well?
Yes, I'm a senior land negotiator for Oventive working the Uinta Basin, and I have responsibility over this drilling unit, among others.
Okay, thank you. I'd just like to remind the board that Mr. Burns will be testifying as both a fact witness and an expert in petroleum land management. Could you please provide, Mr. Burns, the corporate and bonding status for Oventive?
Yes. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is a successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
Okay, thank you for that. I'm going to quickly show you what have been submitted today, or in this cause as Exhibit C, Exhibit D, Exhibit E, and Exhibit F. Can you see those on your screen, and do you recognize those exhibits?
Yes, I do.
And were those prepared by you or under your direction or supervision?
Yes.
Okay. Let's start off with Exhibit C. Could you quickly orient the board and help them kind of get a sense of where this unit is?
Yes, Exhibit C is a regional reference plat showing sections 16, 21, and 28 of 4 South, 2 West, highlighted in red. They are located approximately 3 miles southwest of the Mighton town site and approximately 2 miles south of US 40 in Duchesne County.
Okay, and it looks like it's just north abutting the Greater Monument Butte. Is that accurate?
Yes, that's correct.
Okay, thank you. Moving on to Exhibit D. Could you please walk the board through this?
Yes, Exhibit D is a plat of the wellbore path within this drilling and spacing unit. It just shows the path of the wellbore along with the existing wells within the DSU. Production from those vertical wells has remained allocated on a wellbore basis. Because the vertical wells are tribal, there were no compulsory pooling orders relating to those wells. The Brothers well was completed and began production on May 9th, 2022, as outlined in the RAA. Consequently, conversion of the existing wells to the sections 16, 21, and 28 drilling unit basis occurred effective June 1st, 2022.
Okay.
For the 130-09 order.
Perfect. Thank you. Just to hit on a couple things there from your testimony, to remind the board, there are a couple things unique about Oventive spacing orders that you mentioned there. One is when you do compulsory poolings, there's usually an issue with recoupment. If there are any compulsory pooling orders currently in place and in the recoupment period on the subject lands, there are no orders, no pooling orders on this subject unit. Is that correct?
Correct.
So there will be no recoupment to waive in this hearing.
Right. No recoupment to waive.
Okay, perfect. Moving on to Exhibit E. What does this exhibit show, Mr. Burns?
Exhibit E is a plat showing the 18 different oil and gas tracts within the subject DSU. Oventive is the majority lessee working interest owner in the DSU and is the operator of the Brothers well. Tracks 9, 15, 17, and 18 are tribal oil and gas tracts. As provided in the compulsory pooling statute, royalty under those leases are not included in the calculation of the acreage weighted average landowner's royalty applicable to unleased non-consenting owners.
Okay.
All of the remaining tracts within the DSU are owned in fee status.
Okay, and I'm going to show you this. I'm going to go back to Exhibit D. There, you mentioned tracks 9, 15, 17, and 18 are tribal, and those look like they're identified in green on this picture. So it's a fairly large portion of this unit is tribal.
Yes, it is.
Exhibit F, quickly help the board understand what this exhibit shows.
Exhibit F is just a summary of the working interest ownership, showing the Oventive is the majority lessee working.
Hey, Peter. Peter, sorry, I'm going to interrupt you. Is there any way you could scoot closer to the microphone? It sounds like it's having a hard time picking you up.
Okay, is that any better?
Not much. Maybe you can shout.
Okay, what about now?
That's much better, yeah.
Okay. All right, so Exhibit F is a summary of the working interest ownership of this DSU. Oventive is the majority lessee working interest owner, and we do operate the Brothers well. The additional working interest owners in the DSU are WIM Uinta 2, Big West Exploration and Production, Javelin Energy Partners, who is successor to EP Energy, Press On Production, Energy Exploration and Marketing, Finley Production Company, PEC Exploration, Kaiser Francis Oil Company, Raymond T. Duncan Oil Properties, LCG Resources, Broughton Petroleum, Inc. All of these parties have signed JOAs with Oventive, the terms of which contractually govern well elections, including those elections made on the Brothers Well. Oventive has executed and recorded a pooling declaration, pooling leases pursuant to the authorization contained in the various pooling clauses of the leases, and Oventive is in the process of securing a communitization agreement pooling those leases with the tribal leases.
Okay, thank you for that. So there's less than 0.5% here that is not voluntarily committed to the unit.
That's correct.
Okay, thank you for that. Moving on, I'm gonna show you what have been submitted, and I won't flip through all of them to authenticate, but what have been submitted as exhibits G through O in this cause. Do you recognize these exhibits? And
Yes, I do.
and can you tell them what they are?
These are the various notices of opportunity to lease and or participate sent for the Brothers Well, along with proofs of the delivery of each. The JOA and exhibits P and Q were attached to each. And each of these is an official business record of Oventive.
Okay. Exhibit G, Kent Dukes. Can you, can I take a 2-minute break to talk to the board and division council quickly?
Yes, go ahead.
Thank you. Hold on 1 minute, Peter, if you would.
Sure.
Is everything resolved?
I believe so, yeah.
Excellent.
Are we back on?
We're back on.
Okay. Mr. Burns, in an effort to try and accommodate the busy schedule here today, we're going to move through these a little differently than usual. Typically, these are talked about in length. What I'm going to have you do is just simply identify the owner, whether they responded, and their percent ownership in the unit. Exhibit G. Can you please identify the owner, whether they responded, and what they own percentage in the unit?
Yes, Exhibit G was the notice of opportunity mailed to Kent Dukes. He owns roughly a 0.001365% working interest, and we did not get a response from him.
Okay. Exhibit H.
Exhibit H is the notice mailed to Mary Ellen Sleemaker Binion. She owns a roughly 0.112734% working interest. She did not respond.
Okay. Exhibit I.
Exhibit I is the notice mailed to Scott Dukes. He also owns a 0.001365% working interest, and we did not get a response from him.
Okay. Exhibit J.
Exhibit J is the notice mailed to Shelley Smith. She owns a 0.032651% working interest, and she did not respond.
Okay. Exhibit K.
Exhibit K is the notice mailed to Amy Ibach. She did respond, and we were able to lease her, so she's being removed from the those being pulled today.
Okay, thank you for that. Exhibit L.
Exhibit L is the notice mailed to Kate S. Fowler Markham. She owns a 0.008161% working interest, and she did not respond.
Okay. Exhibit M.
Exhibit M was sent to Leland Woodrow Noble Jr. He owns a 0.004951% working interest, and he did not respond.
Okay. Exhibit N.
Exhibit N is the notice mailed to Slover Minerals LP. Slover owns a 0.257952% working interest, and they did not respond.
And Exhibit O, Tracy Sherrill.
Exhibit O is the notice mailed to Tracy Lee Markham Sherrill. She owns a 0.00408% working interest, and she did not respond.
Okay. And now with each of these letters, you mailed two other documents that are relevant here today. I'm going to show you those, and one, have you authenticate them. Do you recognize Exhibits P and Exhibit Q?
Yes.
And were they prepared by you or under your direction or supervision?
Yes.
Okay. Exhibit P also went with the election letters. What is Exhibit P?
Yes, Exhibit P is just the survey plat of the Brothers Well that was included in each notice packet.
Okay. And Exhibit Q also was included. What is that?
Yes, Exhibit Q is the AFE that we sent with each notice. As Mr. Allison will testify, the AFE was a fairly close estimate of the actual costs incurred in the drilling of the Brothers Well.
Okay. And in addition to the parties identified by me earlier and by you through discussion of Exhibits G through O, are there any other parties subject to this compulsory pooling today?
Yes, as Mr. Mayo mentioned, several lessors claim title in various fee tracts through one or more of the estates of deceased record mineral owners. All of those estates are identified on page 2 of the RAA. And for all of these parties, either no Utah probate of the estate has been initiated, or if filed, it is incomplete and that there has been no proper distribution made to the heirs or devisees.
Okay. Moving on to our favorite, the JOA, Exhibit S. There's a lot in here, but quickly, could you talk about this? Was this prepared by you under your direction or supervision?
Yes, it was.
Okay. And it looks as though this is the JOA that applies to these lands.
Yes.
Is this a standard industry form? Is this one JOA that Ovintiv has used in the past or signed in the past?
Yeah, this is a standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. The terms and conditions contained therein, including modifications made, are consistent with other JOAs executed by other working interest owners in this particular drilling unit and are commonly found in more recently developed horizontal well drilling units. Ovintiv has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin Energy Partners, and other major Uinta Basin operators.
Okay. And I'm just going to quickly address a couple of the provisions that are relevant here today. On page 7 of the JOA, it discusses a non-consent penalty. Can you discuss this provision for the board quickly?
Yeah, page 7 of the JOA outlines the non-consent penalty, which in here is 100%, 300%. And this is the same as contained in the JOA signed by other working interest owners in this drilling unit.
Okay. Now moving on to Exhibit C, sometimes referred to as the COPUS. Can you tell the board, is this industry standard to use a form like this for accounting procedures?
Yes, this is also a very standard industry form, almost universally utilized, similar to other JOAs in the basin. And this page C3 is Article 3B sets the interest rate at the prime rate published in the Wall Street Journal plus 3%, which has been deemed to be fair compensation and to encourage timely payment of chargeable costs and expenses.
Okay. And what about C9 up on the screen currently? What does this address?
Yes, and then page C9 outlines the overhead charges, which is $10,900 per month for the drilling rate, and then $1,090 per month for while the well's on production.
Okay. In your expert opinion, are the terms and conditions of this proposed JOA just and reasonable?
Yes.
Thank you. Now, finally, before we let you go, I want to talk about the acreage-weighted average landowner's royalty. Can you see Exhibit T up on the screen? And do you recognize this?
Yes.
And was this prepared by you or under your direction or supervision?
Yes.
Okay. Exhibit T, can you just quickly walk the board through what this is, what was not included, and what the acreage-weighted royalty is in this unit?
So this big spreadsheet exhibit reflects the calculation of the acreage-weighted average fee landowner's royalty for the sections 16, 21, and 28, 4 South, 2 West drilling unit as of the date of spud of the Brothers well. And this calculation comes to an average weighted royalty of 18.511769%. And this includes royalty provided in lease forms attached as an exhibit to the JOA signed by any unleased working interest owners in the drilling unit.
Okay, just to confirm a couple pieces, 18.511769% is the acreage-weighted royalty that you're asking the board to impose today?
Yes, that's correct.
Okay, and you only included leases in this calculation, including JOA leases in this calculation that existed at the time of spudding the Brothers well?
Yes, that's correct.
Okay, and none of the tribal interests that are in this unit were included in these calculations, is that correct?
Right, fee leases only.
Okay, perfect. Quickly, I'd just like you to address notice. Did you provide notice of this request for agency action to the parties entitled to receive that notice?
Yes, we mailed evidence of the RAA to all the requisite parties. Addresses were derived from a title opinion effective as of February 8th, 2022, as updated by a search of the county records by Lone Wolf, our energy broker, along with our own internal records.
Okay, perfect. Without, I have nothing further for Mr. Burns. If there are no questions from the board or division, I'll move on.
Division.
No questions from the division for this witness.
Board? Yes.
So, Mr. Burns, with the weighted royalty that is assigned to these people that are being forced pooled, what do you do with the royalty for the unprobated owners? Do you suspense that?
Yeah, we will suspense it and continue to try to find any lead we can to try to locate rightful owners. But it's put in suspense until then.
Okay, and as far as the people that are being carried non-consent, when you do a division order, do they need to sign the division order before you dispense their royalty?
For the forced pooled parties, I would have to check with our division order group. I think the board order likely trumps the need for a division order to be signed.
Okay, thank you.
Yes.
Does that 0.4% that you're forced pooling or compulsory pooling include or exclude that little tiny interest that you've leased?
We took that interest out, so this is it does not include that interest.
Thank you. Any other questions? Yes.
So you hold that in suspense and you don't find the people. How long do you hold that, and then you send it to the state? Is that correct?
Yes, eventually it is escheated to the state, and I think I'd have to confirm how many years that is, but it is a couple years before it is escheated.
Yeah, and it's probably not a bad opportunity to plug the Utah unclaimed property .gov. Go on there and check anyone for their names. You'd be surprised for relatives and et cetera. That's the best place to locate any minerals that have escheated to the state.
Back to you. Another? No. Okay. Back to you, Mr. Mayo.
Thank you. With that, I'm done with Mr. Burns, and I'll move on to Mr. Brett Allison. Peter, don't go away. You may be called back, but you're done for now. Brett, are you there? I can't see you yet.
Yep, I'm here.
Okay. Oh, there you are. Brett, can you please state your name and business address for the record?
Sure. Good afternoon, everyone. Brett Allison. We office here at 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay. And your current position and job responsibilities, at least as they relate to this unit?
I'm a reservoir development engineer overseeing our Uinta Basin asset.
Okay. I'm assuming that involves some level of oversight on this unit.
That's correct.
Okay. I'm going to show you the exhibits that you'll be testifying to today. Exhibit U, Exhibit V, Exhibit W. Do you recognize those exhibits?
I do.
And were they prepared by you or under your direction or supervision?
They were.
Okay. On Exhibit U, this is titled Total Well Cost. Can you explain to the board what this is and what it demonstrates?
Sure. Exhibit U depicts the actual costs that were incurred in the drilling, completing of and operating of the Brothers 1H well through April of 2023, which shows it to be within reasonable variance of the original AFE.
Okay. In your expert opinion, were the costs for the drilling and operation of this well reasonable, fair, and necessary?
Yes, they were.
Okay. Was it deemed economically feasible when you drilled it?
Yes.
Okay. Exhibit V. Can you please walk the board through this one as well?
Sure. Exhibit V shows a plat of the nearby existing horizontal wells, the horizontal well developments at the time of the Brothers 1H spud. This shows that there was very few horizontal wells that were drilled in this area, so we had limited offset well control, especially moving to a shallower part of the basin, which increased the risk on the drilling and completing of that Brothers well.
Okay. And there were, I guess at the time of drilling the Brothers well, this was the first horizontal well in the unit, it appears.
Yes, that's correct. First horizontal.
First horizontal, okay. And Exhibit W, you started to talk a little bit about risks. Could you please just tell the board what this shows and if you incurred any of these risks during drilling?
Yeah, really, we have a lot outlined there, but the two primary risks that we had in the drilling of the Brothers well, the first one being the proximity to offset vertical wells in the area, which can lead to pressure depletion, which can inhibit mud properties and lead to lost circulation downhole. And then further, The Utland Butte just inherently tends to have a higher clay intervals, which have the potential to collapse and stick drill pipe and casing during the drilling operations. We didn't see these risks during the drilling and completing of the Brothers Well, but they are inherent to the Utland Butte in this particular area of the basin.
Okay. Let me ask you, one more question that I missed. Plugging and abandonment costs. You don't include those on an AFE, or you do? I don't.
Sorry, go ahead.
No, I don't believe you do. That was a confusing question designed to get nowhere. I'm sorry for that. What would you estimate, Mr. Allison, the plugging and abandoning costs for this well to be?
Sure. Yeah, we're currently carrying a $75,000 P&A cost per well, which is consistent with Uinta Basin P&A costs charged to and by Oventive historically, and that's based upon 100% working interest ownership.
Okay, thank you for that. Finally, after discussion of U, V, and particularly W, Exhibit W, is it your expert opinion that a 300% risk compensation award is fair and justified and reasonable?
Yes, it is.
Okay. If there are no further questions, I'm done with Mr. Allison. I'd turn my time to the Board of Division to ask him questions.
Division?
No questions for the division for this witness.
Board? Yes, Mr. Church.
So, Mr. Allison, this well was brought on May 31st of 2022. So it's been producing over a year, is that correct?
I think.
Yes, it's been online for a little over a year.
I think the date of first production was May 9th, which is
May,
probably the
yes, it was.
But it was 2022. That's right.
Okay.
Correct.
Could you speak to as far as the productivity of the well, what it was completed as, or what its current production is?
I can pull it up 1 second. Yeah, its current productivity is looking pretty strong. It's still in the 200 to 300 barrel a day range, still producing fairly strong. Came online very strong. Came online up over 1,000 barrels a day in the initial production. It's declined off fairly well in that time frame. I know we've cumed roughly a little over 200,000 barrels to date, so it's been a very strong well.
Okay, and just as a matter of curiosity, in the unit to the east of it, the Knoll well came on production approximately the same time. Was that an Oventive well also?
Yes, the Knoll 5H directly to the east, which is the 2 mile lateral, that came online at the same time as this Brothers 1H well. The pad, the well site that they shared with the Knoll 7H, which is the shorter lateral, the 5K, that one came online years back. I don't know the exact date, but I want to say, actually, I've got it.
See, 2017 is the date that I see on.
Yep, that's it. That's it. Yep. It came online in 2017. But yes, all three are operated by Oventive.
Okay, and just curiosity-wise, is the Brothers well and the Knoll well, they have comparable production?
Yes, yeah, the Brothers 1H and the Knoll 5H are very comparable. They differ from the Knoll 7H, being that's an older well and shorter lateral, but the two 10Ks are very comparable.
Thank you very much.
And it's now clear where the confusion came from, Mr. Church. There's a mistake, a typo on this exhibit. Mr. Burns' testimony was, and the testimony is, May 9th was the date of first production. Thank you. With that, I'm done with my case in chief. If the division has anything.
Division, over to you.
I mean, the division doesn't have much to add to this. Mr. Mayo already mentioned that the division filed a notice of non-opposition on June 21st. The division's opinion that the petitioners met the statutory regulatory requirements for compulsory pooling and does not oppose the board granting this request. However, I did not draft that, and it was, in reading that, I did note at the end, it did mention that if the board grants the request, it should impose a statutory risk compensation award of between 150% and 400%. Here they're requesting 300%. For whatever reason, when the division filed that non-opposition, they thought they would inform the board of that they have that range within their purview to adjust that if they felt necessary.
Noted.
With that, as Mr. Lyons said, we feel as though Ovintiv has met the statutory and regulatory requirements necessary to pool these interests. I'd like to, before I conclude, move for admission of the exhibits here today. We can move for admission of all the exhibits. However, Ms. Ibach has been removed, so I was planning on not having that exhibit included. If the board has a preference the other way, that's fine. But I would like to move for admission of exhibits A through J and L through W, as testified about here today, and exclude Exhibit K, which deals exclusively with Ms. Ibach.
That is so admitted. A through J and L through X.
L through W.
W, no X. Okay. They are so admitted.
Okay. With that, I'd thank the board for their time and attention, and I'd move or request that you approve the request as conformed to the testimony here today. Thank you.
Board, do we need consult, or would someone like to make a motion?
Mr. Chairman, I'm prepared to make a motion. I move that we approve the request the item as requested.
I second.
Any last comments? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Mr. Mayo, could you draft the necessary documentation?
I'm happy to do that. Thank you.
Thank you. Hey guys, do we need a break or anything? Do you need a break or anything, or you need a break?
Weird thing about this is I read it. I don't know if this is request a substitute agreement. So they have an agreement before for a surety bond. We'll have to wait and see that one.
Yeah. Okay, let me get rid of this one that's been continued. We will shortly be going to the issue regarding Camp Williams, but so you can come up and get prepared as you need. But in the interim here, I should just note that the next item, number 5, docket number 2023-027, cause number 132-19, has been continued to the July board hearing. Which brings us to item number 6 for the day, which is docket number 2023-028, cause number S0350048, in the matter of the petition for agency action, request to substitute agreement for surety bond in order to guarantee reclamation of the Utah Army National Guard regarding the Camp Williams mine, Salt Lake County, Utah. I would now ask for appearance of counsel.
Microphone, please.
Oh, sorry, thank you. Okay. I thought it was on. Okay, Brooke, I'll do that again.
We'll turn you down.
No, just below exhibits.
So we need to plug in here.
Should we give them Julia?
They're just going to be in front of the board, so they won't be visible here. You would
Okay.
need to show them.
Do you? That's fine. Okay, you have them. Brooke McCarrick, Attorney General's Office, on behalf of the National Guard.
Paula Ferber, Attorney General's Office, on behalf of the Division of Oil, Gas, and Mining.
Over to you, Ms. McCarrick.
The Guard owns and operates a 7-acre gravel mine located within the Camp Williams facility. Camp Williams straddles the borders of Salt Lake and Utah counties. The footprint of the mine is actually within Salt Lake County. The mine is located entirely within the Camp Williams facility and does not impact any other landowners. Sand and gravel are extracted from the mine on an intermittent basis for on-site road maintenance. The Division of Oil, Gas, and Mining has requested a surety bond in the amount of $48,200. The Guard is requesting approval from the board to provide surety in the form of a contract in lieu of posting a bond. A copy of the proposed agreement is attached to the request for agency action as Exhibit A. Additionally, the Guard is requesting an increase in the surety from $48,200 to $292,400 to allow for any future expansion of the gravel mine up to 20 acres. The division is not opposed to an agreement in lieu of a bond, as is reflected in their response and notice of non-objection. The legal basis for this request are as follows. Admin Rule 647-3-111.416 authorizes this board to approve a written self-bonding agreement if an operator can show sufficient financial strength. Utah Code 40-8-14 subsection 3 provides that if an operator proposes reclamation surety in the form of a contract, the board shall approve the form of surety after considering the operator's financial status and assets, history of contractual compliance, facilities available to carry out the planned work, the magnitude, type, and costs of the reclamation activities, and the nature, extent, and duration of the mining operations. Section 40-8-22 authorizes the division to enter into cooperative agreements with other state agencies subject to board approval. I have here with me today 3 witnesses from the Utah National Guard. April Abate is the Clean Water Compliance Manager for the Guard, and she will describe the nature, extent, and duration of the mining operation and the proposed reclamation activities. Ms. Abate can answer any questions that the board may have regarding the reclamation process. Also present behind me is Mike Norton. He is the Finance Director of the Utah National Guard, and he will discuss the overall financial status and budget of the Guard. And finally, we have Colonel Vince Wolf. He is the Director of Installations and Environment for the Utah National Guard. His office oversees all land and facilities licensed and operated by the Guard, and he is here to discuss how the reclamation activities will be financed. The Guard has also submitted Exhibits 1 through 3, which are there are 5 exhibits total. 1 through 3 are pictorials of the mining operation. Exhibit 4 is a notice of intention to commence small mining operations. And Exhibit 5 is a conditional approval requesting a surety bond in the amount of $48,200. The NOI is dated December 2012. The Guard has been in ongoing discussions with the division regarding the agreement for approximately 10 years. The division is amenable to an agreement in lieu of a bond. It's just never been finalized. These exhibits are demonstrative and will assist Ms. Abate in explaining her testimony. At this point, I would like to call Ms. Abate as my first witness and ask that she be sworn in.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Abate, would you, Ms. Abate, would you please describe the mining and proposed reclamation activities for the Camp Williams mine?
Yes, thank you. Good afternoon, Board. Yes, so our mine is on the Camp Williams property. Camp Williams is approximately 28,000 acres in total. The mine itself is just on that northeast corner of Camp Williams that fronts on Redwood Road. At last check, we are approximately 7 acres. This particular photo here was when we had a little bit more land that has since been reclaimed on that south side. But right now we're sitting at approximately 7 acres. We're on the Salt Lake County side of Camp Williams. Camp Williams abuts or straddles Utah and Salt Lake counties. So the mine footprint itself is Salt Lake County. And we are basically just extracting sand and gravel from a hillside. And you can see here, we have a crusher that we bring in. This is a mobile crusher, so this doesn't stay here permanently. This just is used when we are conducting mining operations. We do mine intermittently. This is not something that we do very often. Some years we don't mine at all. And the purpose of the material is just strictly used on Camp Williams. We're not commercially selling it or taking it off site. We're just primarily using this to shore up our own gravel and dirt roads on camp property. And we just use typical mining methods, scrapers, dozers, excavators, nothing out of the ordinary here. I guess reclamation-wise, when it comes time, we don't have any foreseeable plans to expand. However, we do want to keep this for the future. We always want to keep that option open if we need to expand. However, as far as reclamation goes, the plan would just be to do the standard grading and reseeding using a division-approved seed mix. So we wouldn't vary any from the traditional methods that are standard practices at the division requests. And I think that might really be it. Let me just make sure I've covered everything here. Do you want me to talk about the notice of intent, or should we just talk mainly about the mining? Okay. Okay. Okay, that's really all. Yes, any questions?
Division, any questions for this witness?
No questions from the division, thank you.
I have a quick question. So is this hard rock mining, or is this loose sand and gravel that you're mining?
It is a bedrock slope. That's
Okay.
why we're regulated.
Yeah,
Yes.
that's what I was getting at.
Yes, yeah.
Yes.
So, so right now, there's 7 acres. Do they have a small mine permit?
Yes.
And is it going to remain below, is it 20 acres?
Yes, that's the plan.
Okay. And so your increases in bonding is based, can you go through that increase in bonding again? Why it's increasing?
Do you want to go through that? Or well, yeah, so the idea behind this agreement, the way we wanted to craft it was that we wanted to allow for a dollar amount that's current with a 20-acre mine bond based on current rates. And the idea behind that was that should we ever want to expand in the future, that we would have that agreement in place with that dollar amount, and we wouldn't have to keep coming back and revising the agreement.
So, Ms. Abadi, on your small mine permit, did the division have an outline of where you anticipate the maximum 20 acres is going to be?
No, not at this point. The current permit is just for 7 acres. So the idea is that should we want to expand in the future, we would just amend that permit and then map out those additional acres.
You would be coming back to division?
For an amendment, but the idea, the agreement, the financial part would already be in place with this board agreement.
Would be in place in the contract?
Mm-hmm.
Okay, thank you.
This agreement is subleasable under, it says it can be transferred under 40-8-19. Does that give the division any ability to review who you're subletting to, or do you want that ability to know? The guard is going to retain responsibility, but there's nothing about if we didn't approve of whoever they subleased it to. Is that?
We don't really have that authority. There is a transfer that would need to be made if the permittee were going to change, and someone may not qualify for a new permit, but the sale may take place before. Well, We can't tell them not to sell to somebody or to sublease to someone. We can refuse a permit if someone doesn't qualify for it. So
Gotcha.
there have been instances where someone has purchased something, they can't get a permit, they need to sell to someone else, or something else
Okay.
needs to happen.
Okay, thank you.
Two more questions from me. The surety amount of $292,000 for the up to full 20 acres, how will you account for that inflating over time? As is there going to be an automatic inflation of that, or 10 years from now there's going to be a much larger number required for a 20-acre mine?
It is something that probably, the idea was just to account for planning for the future. But no, I don't think, I mean, that's what the point of these bond cost indexes are, is to account for inflation. But I really don't see this mine going up to 20 acres. And our practice would be that once we're done mining this area, we would reclaim before we moved on to another area. So that would just transfer the footprint over. But it was just a way to allow us to stay under the small mine permit regulations and avoid having to come back and keep retweaking the agreement.
Okay. And that feeds straight into my second question. Have you done some progressive reclamation already of inactive quarried areas, mined areas?
There's that little area on the south end that we have reseeded, just on this southwestern boundary. We've done some reseeding and replanting there, but they are actively still quarrying. In fact, we had to mine this year. We didn't mine at all last year. We had to mine a little bit this year because all of our roads got washed out pretty significantly due to all the heavy rains. But it's really just as needed, so it's not a very large operation by any stretch.
Mr. Lucky?
Going to the bonding question, isn't it reviewed in that midterm of the bond permit cycle?
In the minerals program, we review bonds at least every 3 or 5 years, and the permittee can pick which of those, and they'll pay escalated for that amount of years.
Mr. Church?
One more question. On the 20-acre permit, did you need to get some kind of a permit or approval from DEQ for this?
No, we didn't.
No DEQ?
No.
Who actually owns the sand and gravel that you're mining here?
It's all military, federal property, Camp Williams.
It is, thank you.
Any other questions from the board? Seeing none, back to you, Ms. McCarrick.
I have no further questions of this witness. I would like to call Michael Norton as my second witness.
Please turn your mic on.
Can you hear me now? Okay. Can you hear me?
Yes.
Yes.
Okay.
Closer is better, of course.
Okay. I would ask that Mr. Norton be sworn in.
Okay. Yeah, just put it in front of her face.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
I do.
Mr. Norton, could you please describe the financial status and assets of the Guard and whether, to your knowledge, the Guard has ever defaulted on any of its financial obligations?
So the Utah National Guard is the state's defense force with the governor of Utah as the commander-in-chief. In addition to that state role, the National Guard also serves as a reserve force for the departments of the Army and the Air Force. Because of that, we receive significant federal funding to assist in that readiness. So about $350 million a year is the federal funds that the Utah National Guard receives. About 60% of that's pay and allowance, about 40% of that's operations maintenance. And of that 350 million, about 50 million a year comes to the state as assistance for the state providing support for the federal mission. In addition, the Utah National Guard receives about $8 million ongoing from the general fund of the state. We have not ever defaulted on a payment or a bill that I know of, and any default would probably be out of our control and in Washington, D.C.
Does the board have any questions of Mr. Norton?
Over to the division first.
The division does not have any questions for this witness. Thank you.
No flippant questions about the fiscal policy of the federal government, please. But any questions for this witness? Seeing none, thank you. Back to you, Ms. McCormick.
I would now like to call as my final witness, Colonel Vince Wolf.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon. I'm Colonel Vince Wolf, the Director of the Installations and Environment for the Utah Army National Guard. I have worked in various positions within this directorate over the last 20 years and as the director for the last 5 years. I manage the Utah Army National Guard's federal and state lands and facilities. Of the $50 million in federal O&M budget, I am responsible for approximately $35 million of it, in between the installations and environmental budgets. The mine in question is on federal land that the Utah National Guard manages under a license from the Corps of Engineers. When it is determined that we will cease mining operations at Camp Williams, and when I say cease, completely cease, I will program, or whoever's in my role at that time, will program through the federal side to budget the amount of money necessary to reclaim said land, based on whatever the guidance is from the director at the time, whether it's just reseeding, grading, whatever's necessary, and whatever the budget number is, we'll program it in. This way we ensure that we have the proper money needed, because I think I'm in the same boat as you guys. I don't think 200,000 is going to cut it. Any questions?
Division, any questions for this witness?
The division doesn't have any questions for this witness. Thank you.
Board? Mr. Moon. I mean, Mr. Church. Hey, wait till the end. It's going to be really bad.
Colonel Wolf, I understand, so you've come to the state for a permit on a small mine. Are you not subject to other agencies for permits such as DEQ?
Not that I'm
aware
aware
or
of.
county zoning?
We do for, because of our generators, our emergency power generators, we have permits for air as well, and our water system at Camp Williams.
And you've determined that you don't need a DEQ permit then for air quality associated with the mine?
I'll defer to my environmental expert.
As far as I understand it, it's just a fugitive dust control plan might be required, but I think that's only if you're in Utah County. That's a non-attainment area. But because it's Salt Lake County, we don't have a fugitive dust control requirement from the DAQ. But as far as other permits go, oh yes, we are regulated by DEQ. I manage the whole stormwater program, and I have stormwater permits that I have to maintain, so they're there.
Okay, thank you very much.
Sure, thank you.
On an annual basis, just roughly how much material would be excavated from this area?
The first year we took from it, we took roughly 500,000 cubic yards. mostly because we had not maintained the gravel roads and trail systems at Camp Williams for a significant amount of time. What we do when we do it is we contract with an operator such as Hadco to come in. If we have engineers that need training time on, stick time as we call it, driving up the bulldozers, we'll let them come in and operate and push material down. Otherwise, Hadco would bring in their own operators. They would crush rock, and then we'd have it hauled down to the center of the training site out in the Tickville Basin and stockpile the various gravel there, because that Tickville Basin is essentially the halfway point between the far end of the west end of the ranges and from the cantonment side, so it provides a good staging area. And so we would usually do $500,000 worth of a contract at one time, and that usually would, that first contract lasted us until probably this year. They're just about out of their stockpile.
So fairly small tonnage moved every year if you look at the long-term average. It's
the most that happens on an annual basis would be the trails maintenance, or I should say the wash maintenance. They'll pull some 3-inch minus to put in the drainages to keep it from washing out and clogging up the culverts.
Thank you. Ms. Garrison?
So is all the material left on site on Camp Williams? You aren't taking any off-site or selling any of it?
We do not sell any of it. The only time we've ever taken any off was to bring it over to Draper headquarters. But no, we do not sell it. With it being federal land, we don't. Hadco wanted to cut me a really sweet deal if they could have some instead of charging me, but no.
Any other questions? Yes.
So with this bonding at 20 acres, they never have to come back again to the division. Is that to the division?
No, they would have to come back to the division if they go outside of the current disturbed area. They would have to come get an amendment from the division, but they would not have to come back to the board to ask for an increase in this self-bond unless it became larger than what they're asking for today. So I see why they're doing that. But yeah, any change to that footprint or the way they're mining would require them to come give us an amendment and be approved by us.
So the reason they're coming to the board is to be self-bonded.
Correct.
And so since it's being self-bonded, only come one time, get a full amount.
Correct.
Okay, thank you.
Any other questions? Seeing none, back to you.
Well, I have no other witnesses, and this concludes our presentation. I would ask that the board admit exhibits 1 through 5 into evidence, and ask that the board grant the request for a contract in lieu of a surety bond.
Division, any concerns with having those exhibits entered into the record?
No objection to the exhibits.
Any concerns, board? Seeing none, exhibits 1 through 5 are so entered. And that, I think, brings us over to the division, huh?
Yes. As Ms. McCarrick mentioned, the board has the authority to consider the factors in the statute and the rules and to approve a reclamation surety contract or agreement instead of a surety bond. The division has reviewed the request for agency action, the proposed agreement, and the presentation today. And the division has no objection to the board approving the reclamation surety bond in lieu of, or surety agreement in lieu of a security, in lieu of a surety bond. If that's, what the board determines from your review. There's no objection from the division.
Okay. Any questions for the division on the nature of the reclamation surety agreement? Or, yes?
I do, sorry. So they're not posting a surety, they're working out a contract with the division.
Correct. They will sign this agreement that they would pay for the reclamation through this contract rather than posting a surety bond.
And that contract has been reviewed by the division.
It has been reviewed by the division, yes.
And are there, back to this inflation issue, are there any concerns that they'll have to come back in a couple years because of inflating costs?
No, well, the costs go up and down, and the last time we saw a big increase like we did this year, there was shortly thereafter a negative increase in bonds for a couple years. So the economy goes up and down, but as Ms. Abate stated, they would likely keep the footprint smaller rather than ask for additional surety. They would do reclamation in lieu of asking for additional money and a surety, and that could tide them over for quite some time.
Okay, and of course, if they did progressive rehabilitation, then you would have to have someone inspect that and eventually
Yes.
release it saying it was acceptable.
Yes,
And
yes.
so the bond could stay in balance.
Exactly.
Or the reclamation surety agreement. Okay.
Rich?
Yes.
This contract says that it's calculated in 2022 dollars and may be escalated according to the usual rule and practice of the division. Does that give you the ability to go in if you see a need?
Yes, like I said, we look at these every 3 to 5 years. So if for some reason their
Costs went
their
crazy.
plan
Yeah.
required $400,000, we'd have to come back to the board, or they'd have to post surety or something. But we will
But you
look
do
at it
have
on a regular
ability
basis.
to
Yes, we will review
escalate it.
Right. Yes.
Thank you.
And it sounds like this would not happen during our tenure on the board. This is a ways off. All right. Any last statements from either party? Seeing none, I guess do we need to consult on this?
No,
or-
I was just make a motion if that's
All
what
right.
you're looking for. I'll make a motion that we approve a petition for substitute agreement on a surety bond with the National Guard as presented.
Second.
Any last comments? All those in favor say aye. Aye. Let the record. Let the record show that was unanimous. Thank you very much for your time.
Thank you.
Does someone need to write up an order showing this has been approved, or it's just the contract or agreement is what we're,
I believe that we can just execute the agreement.
okay.
That's fine
To-
with me.
But we are happy to prepare an order if you would like one from the board.
Yeah, I think it can be brief, but I think probably for record keeping, that would be appropriate.
Okay, great. Thank you.
Thank you. Thanks for that. I think we'll take just a brief break, maybe start right at 4 o'clock. We are back on the record, and we're moving to the next item, which is docket number 2023-029, cause number 130-21, in the matter of the request for agency action of Excel Resources LLC on behalf of Excel Asset Co. LLC for an order 1, amending the board's order in cause number 139-153, 130-06, 139-140, 139-149, and 600-04 to reduce heel-to-toe setbacks from 330 to 100 for the production of oil, gas, and associated hydrocarbons from Lower Green River Wasatch formations, and 2, partially vacating the board's order in cause number 600-04, establishing overlapping 2,560 acre drilling units only as to unit number 15, consisting of sections 18 and 19, etc. I'll now ask for appearance of counsel.
Thank you, Chairman Borden. Mitch Mayo of Lear & Lear on behalf of XCL Resources and XCL Asset Co.
Charles Lyons, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Over to you, Mr. Mayo.
Thank you. In brief consultation with the board and division counsel prior to this hearing, and in recognition of the fact that this hearing is already going till about 4 o'clock and we've got a couple matters still to go, and further recognizing that the board dealt with a fairly similar request earlier today, a fairly hearty discussion in cause number 130-20 involving the reduction or the establishment of reduced heel-toe setbacks, and also dealing with a transitional zone, we've decided to kind of truncate the testimony here today. And so what we'll be doing will be a slightly different procedure than the board is maybe accustomed to. I will be proffering testimony. So I'll do the similar introductions with witnesses, and they will be there and available. However, I will go through the slides and essentially proffer what these individuals would have testified to at the end of their testimony, if you will. I'll then ask them if they agree with, have any changes to, amendments or clarifications. To the extent the board has any questions, they can ask those of the witnesses. And without any...
Division, are you comfortable with that format?
We're comfortable with that format. That sounds great. Thanks.
Okay, thanks.
Thank you, Mr. Chairman. Again, Mitch Mayo on behalf of the petitioners, XCL Resources and XCL Asset Co. With us today are the 3 witnesses. We do have one substitution. There's a there's a 4th quarter call here. Matt, would you raise your hand? Matt Hempel will be substituting as the land witness for Mr. Kevin Annenson due to a scheduling conflict. I've got a resume for Mr. Hempel. He won't be testifying as an expert, so there's probably no need to look at it here today, but I'll file that with the board after this, so we've got the record of that. With me today are Mr. Matt Hempel, as I noted, and raise your hand when I call your name so they can see who we're talking about. Mr. Matt Hempel, Director of Land for XCL Resources. Mr. Josh Sigler, Vice President of Geology. And Mr. Mark Gravy, the Executive Vice President of Reservoir. Again, I have my cell phone on because they are appearing remotely. If it dings, please forgive me. And could we please have the witnesses sworn in at this time?
Gentlemen, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
Okay. Please forgive me also if this is a little clunky. This is kind of a last-minute adjustment, so I'm going to try and get through it. If I repeat myself, I will try to keep that to a minimum. Before you today, members of the board, is a fairly straightforward request, one that you have seen many times, and in fact, earlier today and approved. There are 2 primary requests at issue today. One is the reduction of heel-toe setbacks from 330 feet to 100 feet. And the second related request is the partial vacation of Order 604, essentially vacating 2 2560 units that essentially, if left in place, won't be drilled and are likely to confuse allocations going forward. The lands at issue today are 2 South 3 West and 2 South 2 West. 2 South 3 West is the entire 1 through 36. 2 South 2 West, it's sections 16 through 21 and sections 27 through 34. To achieve the requests before you today will necessitate the modification of several board orders. Those board orders establish 1280s and 2560 drilling units. In particular, orders 139, 140, 139, 149, 139, 153, and each of those are identified here on Exhibit D. And maybe to back up, each of the exhibits that we testify about today were prepared by XCL personnel and either prepared by them or under their direction or supervision. As to Exhibit C, there are 2 townships at issue here today. Those are just west of the town of Roosevelt and just west of the Uinta County, Duchesne County line. As mentioned, there are 4 spacing orders at issue that apply to 1280s, 3 of them identified here. Order 139, 140 in green, Order 139, 153 in yellow, and Order 139, 149 in blue. Each of those established the 1280s. Order 13006 modified the lateral setbacks on this order, and it's not identified here. The long and the short of it is each of the 1280s at issue here today have the same setbacks that apply. 560-foot lateral and 330-foot heel-toe setbacks. We also have noted on this exhibit this purple box on the right. That is Order 130-16, which you also saw referenced in the presentation for Cause 130-20 by WEM today. That is an Oventive operated unit that extends up into XCL's position. That was, in February of this year, granted 100-foot heel-toe setbacks. Also necessary to modify here today is Order 600-04. We're going to do 2 modifications to Order 600-04 if approved. The first modification is similar to the modification for the 1280s. That is the reduction of heel-toe setbacks applicable to 2560 or drilling unit boundary line wells. The second modification to Order 600-04 is the vacation of these 2 units identified in blue. Without making you count, there are 2560 drilling units displayed here, 18 of them in red and 2 of them in blue. All of the red identified 2560s, the only request here today is to reduce the heel-toe setbacks similar to the 1280s. With the 2560s in blue, those will be vacated effective the date of the 600-04 order, as if they'd never existed. And in order to help explain why that is, I prepared an illustrative exhibit in advance of this hearing to kind of just show you visually what's going on here and why this is necessary. If you go back up to Exhibit E, you can see, we'll look at this bottom blue square here, 30, 31 in 2 South 2 West, and 25, 36 in 2 South 3 West. As was discussed earlier today, and as is obvious here today, XCL's position here straddles the transition zone between laydowns and stand-ups. On this illustrative exhibit, you can see the situation that XCL is trying to address. As of now, under the 600-04 order, Section 30 and 31 and Section 25 and 36 in 2 South 3 West are a 2560 drilling unit with wells to be drilled anywhere within 560 feet of either side of the section line. Put differently, any well drilled between 560 feet west of the section line and 560 feet east of the section line is payable on a 2560 allocation. However, because of the transition, the heel-toe of these laydown wells, there is an argument to be made or a confusion that could exist between what you do with payment allocation on the 230 feet of this well that extends beyond and into that drilling unit boundary well corridor. To avoid that confusion, and because these locations will, based on XCL's preliminary drilling likely not be drilled anytime in the future, if at all, the simplest thing to do is to remove those from the orders to avoid confusion altogether. That is the end of the land exhibits. I did want to also note a couple additional things not noticed on the exhibits. My apologies. Okay, the last thing I wanted to note was notice. Notice area is not identified on this. There's not an exhibit submitted that shows an outline. But notice was provided to all interest owners as required under the statutes and regulations. Certificate of service was also filed in this cause, and it is on file in this in the record. Mr. Hempel, I know that was rambling and somewhat disjointed, but that was your testimony. Do you agree with that testimony? Is there anything you'd like to clarify or change or amend? Anything I misstated?
I think you hit it all perfect.
Okay, so if I asked you, is that your testimony?
Yes, it is.
Okay, thank you for that. And now I'll move on to oh, please, yeah.
I want to make sure people have a chance to ask you or
them,
yeah. Questions.
No, so
Division?
the division doesn't have any questions for this witness or Mitch standing in this witness's place at this time.
Thank you.
Good.
How about the board? No. Okay.
Okay.
Please proceed.
Thank you. Don't go anywhere, Mr. Hempel, but you're done for now. Next, I will be testifying as Josh Sigler, Vice President of Geology for XCL Resources. If Mr. Sigler were here testifying today in full fashion, this is what he would testify about. First, I'm going to authenticate, if I can, Exhibits F and G. Those were prepared by Mr. Sigler and under his direction and supervision. The board has seen these several times, so I won't belabor them. Exhibit F is a type log, typical of a well in this area near the subject lands. And as you can see, it identifies the formations on there. Exhibit G is a cross-section. And what this does is it shows from A to A prime. You can see A up in the top of essentially the northeast of 2 South 3 West. It traverses down southwest generally to the southwest corner of 2 South 3 West and then heads due east. As you can see, what this exhibit evidences is that the formations are continuous across the subject lands. Exhibits I, J, and K were also prepared by Mr. Sigler. Exhibit I is Exhibit I is an incredibly technical exhibit that I'm in no way qualified to testify about. But what I know for sure is Mr. Sigler sitting there would say, I watched WEM's discussion. They had a pretty good discussion about the transition zones. It's not necessarily applicable here because we're a couple 12, 15 miles north. But the general idea is true. You want to meet perpendicular with the primary stress or the max. Mr. Sigler, help me out. What's the phrase I'm looking for?
Mr. Mayo, I'd say if there are some specific slides where you think the expertise is needed,
thank you.
Feel free to go to that expert.
Okay. Mr. Sigler, are you ready? And would you be willing to testify to this one?
I am willing to testify to this slide. It is Exhibit I, and it was prepared under my direction. As Mitch mentioned, we have recorded stress orientations throughout our acreage, and much like what the good Dr. Phillips described previously in his testimony, we do see that the orientation of maximum principal stress, maximum horizontal stress, rotates from the western side of our acreage over to the eastern side of our acreage. And for maximizing the recovery of hydrocarbons, we want to drill our wells perpendicular to those stresses such that fracture planes will grow along that, optimally along that maximum stress orientation. We do see that transition across our acreage as we move from the boundary of 2 south, 3 west, where we have laydowns oriented, again, perpendicular to those stresses, over to 2 south, 2 west, where we are drilling our stand-up units and have wells that are, again, oriented roughly perpendicular to those stress orientations. What we have also, now, what that almost necessitates is that there is a transition between those laydowns and stand-ups, as noted by the green line that is being pointed to by Mr. May. And as part of understanding this field and understanding whether 100 our asset and understanding whether 100-foot setbacks are appropriate, we have gone and collected vertical well image logs that give us a great resolution on, as Mr. Phillips described, both borehole breakout and induced fractures that can help us identify how that stress is rotating. I'm not going to go into great detail, but can if necessary. We have collected additional logs since the last time we met with you to understand how narrow that transition zone is and whether 100-foot setbacks are appropriate on the eastern boundary of 2 south, 3 west. And what we have found through that is that they are, that the transition zone is relatively narrow. It is not a wide, broad zone, but rather a pretty sharp transition right along the axis of that green line there. And as such, that's the basis for our application for reduced setbacks there. In the sake of brevity, I'm going to just defer to going on to additional displays here. J and K, they effectively show a conceptual diagram of how 100-foot setbacks work. First in Exhibit J, in the laydown units, where our drainage radius of reservoir drainage that will be described later by either Mr. May in favor of Mr. Gravy or Mr. Gravy himself, show about a 153-foot drainage radius. But when we take that drainage ellipsoid and turn it about the axis of that horizontal stress, we find that we would have about 81 feet of drainage offset from a point of a last perforation, if you will, 100 feet from the unit setback. And with 81 feet of forward drainage, that would still leave 20 feet that would provide for the preservation and ability to not have drainage onto neighboring units. In Exhibit K, we show the same thing for a stand-up well. And again, there with that 153 foot, we have 74 feet of forward drainage, leaving 26 feet of buffer between our drainage and the unit, the adjacent unit, thus preserving the minerals to be drained by the owner of that unit. That's a pretty quick summary there. Mitch, anything else you would like to offer as part of my testimony?
Well, no, I won't offer anything. I'll ask you one follow-up question, though. It's just kind of the sum-up question. I know you rushed through stuff, and there will be follow-up questions, no doubt, by the board. But based on what you've testified about, do you believe that a 100-foot setback is protective of correlative rights while also maximizing resource recovery in the area?
Absolutely. We believe that the data we have today shows us that this is a very appropriate plan of setbacks.
Okay. Let me ask you one follow-up question that I don't know you're prepared for necessarily. The oventive order that extends up into your asset, that 130-16, I believe, I could be wrong on that. XCL received notice of that request for agency action when it was pending. Was there an internal discussion and decision about that based on the data they presented?
Absolutely. As offset operators to their own request and the fact that they're then drilling directly south of units that we have previously developed, there was a fair amount of internal discussion as to whether those setbacks were appropriate. We basically conducted the exact same analysis we're presenting here and found that their request was appropriate. And as such, we did not protest, and they have been subsequently granted those setbacks.
Perfect. Okay, thank you. With that, I'm done examining Mr. Sigler. If the board or division have questions. I know Mr. Peterson has a couple of zingers, so we'll get to those. Hold on.
All right, to you, division, for questions.
With the board's permission, I'd like to have Mr. Peterson ask
Please.
a question of Mitch and/or his witness.
So excuse me, but as an engineer, I love to find questions, or Mr. Church might have beat me to it if we didn't jump in here, but I want some clarification on.
Absolutely.
On
I love your question.
F. And Mr. Sigler's, he knows this is coming. So Mr. Sigler, do you want to tell us where the, in our request for agency action, where the top of the Lower Green River should be on this exhibit?
Well, I believe you and I have a slight difference of opinion. I do think that the Lower Green River starts at our interpretation is that there is a fundamental depth change to the depositional system right around the TGR3, but it could also, by different geologists, be interpreted to be at the Mahogany Bench instead of there at the TGR3. And I accept that is a reasonable difference of interpretation.
Between an engineer and a geologist.
Or geologist to geologist, or geologist and landman, if Mr. Mayo has a difference of interpretation.
Okay, so yeah, we see generally in the basin, we see the top of the Green River defined at the top of the TGR3. I just noticed in this request for agency action, the previous owner of your company, for some unknown reason, had referred to the top of the Lower Green River and had it in their spacing on the original request as the mahogany marker. So, and you've got Exhibit F and you've got Exhibit G. I noticed that the two of them were different, and it's not often an engineer notices an error in geology, so I had to make that point.
They're good questions for sure.
I think that's the only question I have for Mr. Sigler.
I'll take up difference of interpretations with Dave Schmoody any day. Might be a beer involved, but we'll definitely do it.
And just to clarify for the record, I believe he was talking about Axia Energy, the successor in interest in your asset, not the previous owner of your company, but that's who you are.
Correct, yes.
Thank you.
Axia.
Yes, right, okay. With that, board questions for Mr. Sigler?
All done with your questions
As
then?
long as Mr. Peterson has been entertained and has everything,
Okay.
We're good to move on from here.
Questions from the board for this witness? Any? Yes.
So, Mr. Siegler, do you want these two exhibits to go into this permanent record in conflict?
We actually have amended exhibits that we will refile as such to match with that difference of interpretation.
I think that'd be helpful for future reviewers.
Yeah, absolutely.
Similar to what you heard earlier, this month's calendar was a little chaotic with the board and division and people out. There was a request from the division for supplemental exhibits. Those just got officially filed yesterday. They were filed by me a couple weeks ago. They just got officially filed yesterday. So I thought about filing them and figured it would be easier to discuss the differences here than it would be to hope they'd been filed and you'd had a chance to review them. But we'll get those filed after the hearing.
Any other questions for this witness? Seeing none, back to you, Mr. Mayo.
Thank you, Mr. Sigler. Same thing, stick around, but you're done for now. Moving on to my final witness for this matter, Mr. Mark Gravy. Will you please state your name and business address for the record?
Sure, Mark Gravy, Executive Vice President of Reservoir. Our office is at 600 North Separate Drive, Suite 390, Houston, Texas.
Okay. And based on earlier stipulation, I'd like to remind the board he'll be testifying as an expert in petroleum reservoir engineering today. Mr. Gravy, I'm going to show you what we've got here as Exhibit L and Supplemental Exhibit M and Supplemental Exhibit N. You recognize these, and did you prepare these?
Yes, I do.
Okay. Starting with Supplemental Exhibit M, I'm going to save the board from my attempts. Would you please explain quickly what this shows?
Absolutely. This is an output from a numerical model of a horizontal oil well from a commercial software called IHS Harmony. In this case, we are modeling the Bobby 66-3526-220 with the reservoir properties shown on the screen. We extracted core adjacent to this wellbore, took data from that core, and we observed a permeability of 0.34 microdarcy, porosity of 8.4%, and oil saturation of 45%. And then after completing the well and seeing it produce, we observed an initial reservoir pressure of 7,500 PSI. And then from sampling the oil and doing geochemical analyses with the company and their proprietary companies called Revochem, we interpret a height of 200 feet. And so the purpose of the software is you put the petrophysical information you have into the software, and it matches the oil, gas, water, and pressures observed from its early life, and then estimates the drainage profiles from that well. So those drainage profiles are shown on the screen. At 250 days, there's roughly 135 feet of drainage. At 500 days, it's roughly unchanged. And then at 900 days, it slowly extends outwards to 160. And so if you go from there to Exhibit N, Exhibit N is an analytical model comparison. So many operators and division have used Hale and Evers as an opportunity to look at the drainage of the wellbore. And so estimating the permeability, porosity, viscosity, compressibility, time, you apply that to this model, and it estimates two radiuses of an ellipse. And so the primary radius, the longer radius, would be roughly the drainage of 153 feet using the same information shown on the screen, and a minor ellipse of 73 feet. We found this model to be close to the commercial software, which was good confirmation. And then in addition, that minor radius, that shorter radius of 73 feet, is very close to the cluster spacing that we have put in many of our wells. And so a cluster is a hole in a casing that's going to interact with the reservoir, and you add them in order to prevent them from being a loss of resource. So that was another good confirmation that we have many producing wells with that cluster spacing. Through time, we believe that it actually should be closer, which would suggest that it's a smaller drainage than that. To date, we're putting our clusters about 20 feet apart from one another. But because these two models agreed well with each other, we felt comfortable using the Hale and Evers. So that 153 feet is the same distance Josh showed in the previous exhibits, and is also consistent with what other operators, including the unit you referenced earlier, have been used to support heel toe setbacks in the area, as well as, which wasn't mentioned, several other units immediately south of our position that have also been granted 100-foot heel toe setbacks.
Did you just say, Mark, to clarify that part of your testimony, did you say that this unit, 130-16, is this the unit you were talking about when you said that unit?
Correct.
Yes? Okay. Thank you. That was all.
Yes, that is correct.
That was all for clarification on that. Supplemental Exhibit N, is there anything else you'd like to discuss about that, the Hale and Evers?
No.
Okay. Then I'm going to move you on to your last exhibit, Supplemental Exhibit L, or just Exhibit L, economics. Can you walk the board through this quickly and explain the benefits financially to this?
Sure. In the top right, we have a cumulative probability plot. So that's an estimate of how much oil is recovered. The middle point is about 95 barrels of oil per foot. And applying that to the increase in lateral lengths, we anticipate an incremental 45,000 barrels of oil to be recovered over the life of the well, which increases the tax revenue by roughly $200,000 per well, the royalty revenue by $400,000 per well, and across the spacing unit with 12 wells in it, would increase tax revenue by $2.2 million, royalty revenue by $4.8 million. We are prompted to do this analysis, one, because many other operators have done it. We do feel that it's appropriate to be consistent with what they've been granted, but also because of Mr. Moon, who encouraged us to do this analysis at our last hearing.
One follow-up question, Mr. Gravy, same one I asked Mr. Sigler. Based on the exhibits you testified about and the testimony you've given, do you believe 100-foot setbacks are protective of correlative rights offsetting and that they also maximize resource recovery and prevent waste?
Yes.
Okay. With that, I have no further questions for Mr. Gravy, and I'll turn it over to the division and board.
Division, any questions for this witness?
Mr. Peterson would like to address one.
Yeah, I think we should clarify something just for the board, Mr. Gravy, and I'll ask you a few questions about it. But you've got the transition area between your laydowns and your stand-ups, and I know you've tried to locate that best you can, that transition. And I guess I'm going to say kind of a true-false question on that is there's some question about as you go through that transition, that stress direction is going to be a little different where you're not as vertical with your principal stress direction for your laydowns or horizontal for your stress orientation for your stand-ups. There's going to be some in between on those where you have more risk of encroaching on your drainage, will encroach more on your neighbors. Is that not correct?
I think that is correct as the transition. But in our estimates of how it transitions, we found the setbacks to still be appropriate.
Okay.
I would agree with you that as it transitions, that is happening.
Okay, I just wanted to clarify that. We've looked at them in-house and after seeing your evidence and talking it over with you, but that transition does occur here. That could be of question. We're not sure how sharp it is, but that transition, but you know, we're not questioning your proposal. Just wanted to clarify that if there's any area where there could be question, there's slight drainage here, but it's later in the life of the well, it's minor. And I guess we could say you couldn't fit that situation any better than what you propose. Is that correct?
That is correct.
Okay, that's all I wanted to make clear.
Appreciate it. Board, questions?
Board, any questions? Yes, Mr. Church.
Mr. Gravy, just a matter of curiosity. The Bobby 2066 well that you used as a match to the core extracted, you say that's an interior well. Is that's an interior well to one of these causes? I didn't see where it was on the map. That'd be helpful. Was it a lay down or a stand up well?
I believe it's a stand up, and it they look.
It is a stand up. It is. If you'd like to bring up the map, Mitch, I can point out where that well is if you'd like.
You tell me which map.
The one that had the exhibit orders on it that referenced to Rich's request for the heel toe setbacks.
Well, let's see if I can find it. It is here. There we go.
That. We're seeing the camera, not your screen, but it is one unit.
You don't see my screen, Mark?
That is correct. We did not see your screen.
Okay, hold on one sec. We'll see if IT can get you sorted out. Yeah, do you have a township and range section, Matt?
It's the unit between the Oventive, there it is, it's, 3526. 2635. Sorry, yeah, it's roughly where your mouse is right now.
2635, 2 south, 2 west.
The interior, as in, it is in the middle of that unit.
So just to clarify, Mr. Church, it's just outside of the lands in this request, but it's between those lands and the other approved 100-foot heel-toe
Okay,
setbacks
so
between them.
that's where the word interior well comes from.
That's right. It's not interior in the subject lands, it's interior between these two. Just poorly worded, probably.
Okay, and it's close to the core that you analyzed, and I'm not sure
Correct.
exactly where the core.
The core is at the south end of section 35.
Okay, good. That helps me
Thank
get
you.
the geographics on. Thank you.
And the reason those wells were not included in this request is because they are already producing.
Sure.
Is that it? Yeah. Any other questions from the board for this witness? Seeing none, back to you, Mr. Mayo.
With that, I'm done presenting our case in chief. I think it's probably appropriate to move for admission of our exhibits at this time, and let me see if I can actually figure out what those are. No, I cannot. I'll come up with a comprehensive list, but it's, I believe, exhibits A through L and supplemental exhibits M and N. I also provided that illustrative exhibit. It's not new evidence. It's not substantive in any way, but if the board would like us to, we can file that as well.
Did you present Exhibit H? I don't remember seeing that.
A through L, A through G, and I through L.
Okay.
I'll get a comprehensive list, but I'd like to move for admission of our exhibits here today, if that's okay.
Okay, so any concerns with the exhibits being entered?
No concerns with the exhibits presented.
None from the board? Okay, exhibits A through L, I through, excepting
Exhibits.
H.
That's right.
Supplemental exhibits M and N are so entered.
Modify
And-
one of those.
And one of those is modified. Yes.
Thank you. Perfect. We will sort that out.
Which one is modified? We need to have that.
It was F and G that I think Mr. Peterson pointed out. One of the two or both of the two needed to be F. He'd like to see corrected.
F needs to look more like G.
Okay. That's the correction. It corrected exhibit F. So to clarify, A through E, corrected exhibit F, exhibit G, exhibits I through L, and supplemental exhibits M and N. I finally got it together on that one.
Okay, we're all in agreement, I believe.
Okay, perfect. I'm done until division proceeds.
All right, division, over to you, huh?
I guess the division doesn't have much to say in sum, except for it generally, supports the request, doesn't have any opposition to this as presented.
Board, any questions for the division? No? Mr. Mayor, would you like to sum up?
I would very briefly like to sum up. XCL has presented the technical information here today to justify these setback reductions. And I will say the division took a really hard look at this over the last couple weeks. There's been a significant amount of back and forth. And to me, for the division to get to a point where they say, we essentially support this is a pretty big step. With that, I'd urge that you approve this request as testified to today. Thank you.
Board, I would entertain a motion unless somebody feels the need to consult on this.
I'll make a motion.
Okay.
I move that we approve the request for agency action as presented.
I'll second.
Any last comments from the board before we vote? Seeing none, all those in favor say aye. 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 Let the record show that was unanimous. Mr. Mayo, could you prepare the necessary documentation?
I'm happy to do that, Chairman. Thank you.
Thank you. Yes.
Say something about Mr. Moon not being here as far as unanimous?
Yeah, we're missing 2 board members, of course, right now, but we're still at a quorum, huh? Mr. Moon is not here, though he was in attendance the rest of the day, huh? Okay. I believe we're ready to move on then to the last docketed item.
Thank you, guys. And board members, if I could make a public scene excusing and embarrassing Mr. Sigler. It is his wedding anniversary tonight. So he is going to, if the board is all right, sneak out and have Mr. Gravy testify. There's limited geological testimony for the next one. If the board has any concerns about that, please make him stay. He'll be fine. If not, I'm going to let him go.
If I can go to my birthday party tonight.
Yes. Let's go. We're done.
Thank you,
Thanks,
Mitch,
Josh.
and your honors.
Congratulations.
Thanks, buddy. Thanks, Leslie. Really appreciate it.
Do you need a couple of minutes to retool, Mr. Mayo, or you?
I'm going to go as quickly as possible, and I think I'll be ready here. Do you guys, witnesses, do you guys need a minute, or are you guys ready to roll?
Ready.
Board, you?
You need to admit, Comcast.
Oh, yeah, I'll get there. Do you guys, did you hear what the stenographer said? She asked if you could either speak up or move a little closer to the speaker. It's kind of difficult hearing some of you. And you might want to just move it in front of each of you as you testify, because it seemed like it was easiest to hear Josh and hardest to hear Matt and Mark.
I think that's most appropriate, suited closest to the person speaking.
Okay.
Yeah, we can do that.
Perfect. Members of the board, again, Mitch Mayo.
Let me read it in
appearance.
first.
Thank
and
you.
I was just giving you a moment.
I'm
Last item today is docket number 2023-030, cause number 135-02, in the matter of the request for agency action of Excel Resources LLC on behalf of Excel Assetco LLC for an order granting exception location for the Maximus 583231-23L well located in sections 31 and 32 of Township 2 South, Range 3 West. I'll now ask for appearance of counsel.
Mitch Mayo of Lear & Lear, on behalf of XCL Resources and XCL Asset Co., the petitioners in this cause.
Paula Ferber, Assistant Attorney General, on behalf of the Division of Oil, Gas, and Mining.
Thank you. Over to you, Mr. Mayo.
Thank you, Mr. Chairman, members of the board. I'm going to try and keep my introductory comments brief. As I said, I'm here representing the petitioners, XCL Resources and Asset Co., and with me today are 3 witnesses, one of them different from the prior cause. Mr. Matt Hempel, Director of Land for XCL Resources, Mr. Tom Castens, who is the Vice President of Drilling at XCL, and Mr. Mark Gravy appearing again, who's the Executive Vice President of Reservoir. He will be filling in for Mr. Sigler on this one. Could we please have the witnesses sworn in at this time?
Gentlemen, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Each of the witnesses' resumes have been submitted as Exhibit A or will be submitted as Exhibit A in the case of Mr. Hempel after this hearing. And if asked, they would confirm them as true and accurate. To remind you, Mr. Hempel will be testifying as a fact witness in petroleum land management questions. However, Mr. Cassens and Mr. Gravy will each be recognized, hopefully, as experts in their respective causes. Both have appeared before this board and both have been recognized as experts in prior causes. Mr. Castens was recognized as an expert in drilling operations in cause number 475-01. And Mr. Gravy was recognized as an expert witness moments ago in cause 1. In cause 130, sorry. Cause 130-21. With presumed stipulation from the division, I'd like to ask that both of these individuals be recognized as experts in their respective fields for purposes of this cause.
Division, any concerns?
No objection from the division.
Board? Seeing none, they're recognized as expert witnesses.
As is customary, I'll hold on and move for admission of exhibits at the end of our case in chief today. Really, the question before you today is fairly simple. XCL did what most of us do in our daily lives. They made a mistake. They drilled a well that they drilled fairly accurately. However, there was a planning mistake. And the question before you today is whether this well can be completed as drilled or whether it can't. Specifically, XCL is before you today seeking an exception location to complete and produce the Maximus 58-3231-23L well. It is the southernmost well in a laydown unit that will be described here today. It's got an as-drilled surface location off lease, and the first and last productive intervals are located 560 feet from the south section line. However, portions of the productive intervals located in the middle of the wellbore are located as close as 445 feet, 115-foot departure from that setback. The subject well, as I said, is the 9th and southernmost of a batch of wells drilled and that will produce from sections 31 and 32 in townships 2 South, 3 West in Duchesne County, and that is a regular 1,280-acre drilling and spacing unit that was established by this board in cause number 139-153, and that had its setbacks amended slightly to its current setbacks in cause number 130-06. Collectively, those two orders may be referred to as the current orders. To be clear, those current orders authorize, as of today, 560-foot lateral setbacks and 330-foot heel-toe setbacks. This well, the Maximus well, does not meet those setbacks. It is 115 feet closer to the south. To be clear, XCL doesn't seek an exception to any of the other setbacks, north, east, or west, simply to the south. By way of background, batch drilling wells such as this takes months of planning and execution. XCL has been doing this for the past 18 months with this unit. They've invested significant money in this, including the drilling of the 9 wells. As is customary, prior to completing the wells, XCL obtained as-drilled survey plats, identifying the location of each of the wells with higher accuracy than industry standard. This heightened surveying revealed that the subject well had unintentionally been drilled in a location such that the middle portion violated the setbacks. Upon realizing the subject well's deviation, XCL immediately began discussions with the offset operator to the south, Ovintiv USA, Inc. The Ovintiv expressed no concern to XCL. However, the offsetting units have large chunks of Sitla-owned and tribally owned minerals, and given that Ovintiv was uncomfortable, I think I'm comfortable saying, signing a written consent for administrative approval of an exception location. Because of that, XCL determined the best way to do this would be to go before the board, explain the case fully, and provide full notice to the tribe and Sitla so they had an opportunity to participate. XCL did just that. They mailed this request to the tribe and to Sitla. When I say the tribe, I mean the Ute Indian tribe of the Uinta and Ouray Reservation and or the Ute Distribution Corporation. To be clear, that they were both notified and did not object. There was one objection filed in this cause and actually it was a response, not an objection. It was filed by Ovintiv USA Inc., the offset operator to the south. And that objection or response was 7 paragraphs, 6 of which were factual in nature, and the 7th said essentially to preserve the right to appear at this hearing and present evidence should it be necessary. Ovintiv is not here today to participate, and in conversations with their counsel, Mark Burghardt, they no longer have the same objections they had. They weren't contacted by the tribe or SITLA to come and participate here today. On June 22nd, nope, that did not happen. Yeah, with that, I'd like to start and call my first witness, Mr. Matt Hempel. Matt, can you please state your name and business address for the record?
Yes, Matt Hempel, 600 North Shepherd Drive, Suite 390, Houston, Texas.
Okay, and could you spell your last name? I don't know if that's something still that Michelle leads, but do you? Yeah, could you spell your last name for us?
Himpele.
P-E-L-E, okay, perfect. Matt, can you, what is your current position with XCL?
I am the director of land.
Okay, and do you exercise a supervisory role over the land records associated with the subject unit?
Yes, I do.
Okay. Could you please provide XCL's corporate and bonding status?
Yes, XCL is a Texas corporation in good standing, having its principal place of business in Houston, Texas. We are fully bonded with all relevant federal, Indian, and state of Utah agencies.
Okay.
One question. I can still see there's a little slack on the line for the speaker. Could you just try and get it even closer? It's still a little distorted.
Hopefully that's a little better.
You can't hide anything from us.
Okay, now try it again, Matt. Let's see if that's any better, would you?
Is that better?
That's much better for me. Yep. Now, real briefly, can you please explain to the board the relationship between XCL Resources LLC and XCL Asset Co. LLC again, just so they're clear?
Yes, so Asset Co. is where the Asset Co. is where the Asset Co. operates. Resources where the employees live, and there's a management services agreement such that Resources manages on behalf of Asset Co.
Okay. I'm going to turn you to Exhibits C and D. Do you recognize these exhibits?
Yes.
And were these prepared by you or under your direction or supervision?
Yes, they were.
Okay. Briefly, please walk the board through Exhibit C. Where is this unit located?
Yeah, so this is a regional area map depicting the location of the subject unit within the basin. The subject unit is approximately 10 miles west of Roosevelt and about 8.5 miles northeast of Duchesne.
Okay. And does this map show anything different, or is there anything you'd like to address on this?
Just to close her up.
Okay. And I'd like to, well, we'll save that. I'd like to move on for you, Matt, and have you quickly look at what was submitted as Ovintiv's response to the request for agency action here. In particular, page 2, there's a visual depiction on that I wanted you to talk through. Do you recognize this?
Yes.
Can you tell what it is, or maybe help explain it to the board?
Yeah, so it appears to be a screenshot from the division's online records identifying the subject unit and the offset units. The offsets are a 1280 comprised of sections 6 and 7, 3 south, 3 west, and a 640 comprised of section 5, 3 south, 3 west.
Okay. Now, if I go back to your slides you just talked about, I'm just going to have you confirm. So this is the 1280 that's depicted on Oventive's. Oh, excuse me. Is this 6 and 7? Is this the 1280 that's depicted as Oventive's that's considered one of the offset units?
Yes, it is.
And this is section 5, the other offset unit?
Yes.
Okay, thank you for that. When XCL first learned that the subject well had deviated, was drilled in a location that was beyond the setbacks, what did XCL do?
We determined that Oventive operates the offset units, and we reached out to them to ask for the names and addresses of the remaining owners, and also if Oventive had any objection to the exception location being granted.
Okay. And how did they respond? I mean, what is your recollection of how they responded?
That there were no other, they were the only owner. There were no working interest or UMI owners in the offset units. And they also stated that most of the minerals underlying those offset units were owned by Sitla and the tribe.
Okay, so there are no other lessees. Oventive is the only lessee, and there are no unleased mineral interests in those two offset units.
That's correct.
Okay. Do the tribe, you said that there are significant chunks of tribal or Sitla ownership in the offset units. Do the tribe or Sitla own any minerals in the subject unit, the Maximus well unit?
Sitla does not, but the tribe owns a little more than half of the minerals in the subject unit.
Okay. And how did, I don't want to, I'm gonna skip that question, given Oventive's essential withdrawal of its response here today. Under Utah Code, the Utah Administrative Code 649.3-3, if Oventive, as the only owner of an offset unit, had consented in writing to the completion, is it your understanding the division could have approved the exception location administratively without needing to come before the board?
Yes.
Okay. Did you pursue that written consent from Oventive?
Initially, yes, we did. We're aware of the time and resource constraints that hearings such as this place on the board and division, so try to use the administrative approvals whenever possible. However, with it being Sitla and the tribe, they're savvy institutional mineral owners. As such, they might have concerns that would be best addressed in a public hearing.
So you essentially chose to go a different route and do a full hearing with notice, an opportunity to object publicly.
Yes, that's correct.
Okay. Did XCL provide notice of this hearing and the request to the tribe, the Ute Distribution Corporation and the Ute Indian Tribe of the Uinta New Ray Reservation, and to Sitla?
Yes, we did.
Okay. Have you received any response from the tribe and or Sitla?
No, we have not.
And have you been notified by Oventive or anyone else that they've received commentary from the tribe and or Sitla?
No, we have not.
Okay. With that, that's all I have for you, Mr. Hempel. I'll leave it to the division or the board to ask you follow-up questions.
Division?
With your permission, I'd like to defer to Ammon McDonald or Orlin Wallace to ask questions of this witness.
Of course.
One quick question. In consideration of speaking with Oventive, did XCL also consider plugging the well back and re-drilling the well to comply with the setbacks that are required?
And that, I don't know if it's a land question. That might be more of a Tom question, but you guys tell me, witnesses. Is that okay?
Yes,
I'll take it.
Well, how about we hold off then, if that's all right? We'll put a pin in that, and in a few minutes when we talk to you, Tom, we'll ask that again. Okay.
The division has no further questions for this witness.
All right, board, any questions for this witness?
I guess quick question. So when you're surveying these locations beforehand, is it done internally or a licensed surveyor or for the drill locations?
I think that can probably also be handled by Tom when he talks about the drilling.
Okay.
Sir.
Bulk of the testimony today will be the drilling operator, and he'll kind of walk through. So any of those questions probably be better with him.
And my question may also be deferred, but so there's a deviation within the setback of 115 feet, did you say? But for how long along the length of the 2 miles? Was it a couple hundred meters? Was it, I'm trying to get a feel for the significance of the.
Without jumping ahead, I'll say it's a good chunk in the middle.
Okay.
And then I'll let Tom kind of address that through his testimony, which will be moments away.
Okay, I can wait. Thank you. Any other questions? Please proceed then.
Okay, thank you. Mr. Hempel, you're done for now. Please don't go anywhere in case there are follow-ups. Moving on to the witness in the middle, Mr. Tom Castens. Tom, can you please state and spell your last name, last name, and your business address for the record?
Yes. Tom Castens, last name Kastens. Vice President of Drilling Engineering for XCL Resources. Our office address is 600 North Shepherd Drive, Suite 390, Houston, Texas 77007.
Okay. And what is your current position with XCL?
Vice President of Drilling.
Okay, and I'm assuming you were in charge of the drilling of the Maximus well at issue?
Yes, sir. Yes, sir.
I'm going to show you what we've submitted as exhibits E through J, E, F, G, H, I, and J. Do you recognize those exhibits, Mr. Castens?
Yes, sir.
And were those prepared by you or under your direction or supervision?
Yes, sir.
Okay. Starting with exhibit E, titled the Maximus 58 plat. Fairly self-explanatory, but could you please point out anything on this that's important for the board to know?
Yeah, so this is a post-drill plat. Part of our standard operating procedure is to take our final surveys, get with the third-party surveyor just to make sure we outline where our heel and toe work can be, to make sure we stimulate the correct portions of the wellbore. As you can see here, the red line is the actual surveys. And the line just above that is the 560-foot setback that mirrors the sections 3132. To answer your question earlier, it's about 2/3 of the lateral, with the maximum being 114 feet south of the setback towards this unit line. The other thing I'd like to point out is here we have 3 sections. If you looked at sections 32 and 33, the center and the one on the right, you see the traditional rectangular shape.
I'll show you this exhibit.
That those DSUs are. The drilling spacing unit in question has a very unorthodox jog to the south. And as we get into it, it's that jog along with what we now know is a flawed procedure that caused the middle of that line to cross the setback line.
Okay. So would it be fair to say without getting ahead of your testimony that this was more of a planning mistake or a procedure mistake than a drilling mistake?
Yes, sir. It was a planning and procedural error.
Okay. Just to clarify your testimony, XCL operates a pretty sizable position. Are most of the units you operate rectangular, standard rectangular shape?
We have not encountered and don't anticipate encountering any operated units that have a shape other than a rectangle.
So this is the only unit you operate that has a funky boundary, if you will.
Yes, sir, that I'm aware of.
Okay. Moving on to Exhibit F. Let's talk a little bit about that procedure, kind of what you did, what happened, and what you've learned from that going forward.
Yeah. I'm not sure I understand. Well, sorry, my watch phone. as being in charge of the drilling department, mistakes happen, man-made error happens. One of the things we try and focus on at XCL is acknowledging that that is going to happen once, but not letting it happen twice. And so kind of want to go over with you what our permitting procedure was, and how that was flawed and what we've changed since then to make sure that I'll never have to stand up before you again and ask for an exception location. So as Mitch referenced earlier, we started planning this wellbore about 1.5 years ago. And the way that is passed down to drilling and permitting is geology and reservoir give us a formation they want to drill and a bottom hole location that they've looked at, spaced relative in a unit to other wells that they think will be economic. We then send that bottom hole location to a third-party surveyor along with our desired surface location. And what they do is they take that bottom hole location, and in this case, it was 610 feet from the south line, and they copy it at the other end of the DSU for the heel. And so you put a heel penetration point at 610 feet from the south line, and then they draw it back to surface. We then take that plat and send it to a third-party well planner. Those well planners then take your plat that shows a surface location, a heel at 610 feet from the south line, and a toe at 610 feet from the south line, which is about 50 feet inside the setback. So when we try and drill a setback well, we give ourselves 50 to 100 foot buffer just to make sure we don't encroach on the setback. And so this is where the problem went wrong. By straight lining that from heel to toe, because of the unnatural shape of this unit, it pulls the center of that lateral into the setback. And so on the directional plan, it was straight lined point to point. The other mistake that was made on the third-party well planner's part that made it visually to where nobody caught it as it went through the process is they drew the setbacks at 330 feet on the north and the south instead of the 560 feet. And that's not documented anywhere else except visually. And so our way of catching that would have been to count how many boxes from the section line to the setback. But to the eye, it looked like our plan, the plat, everything was 610 feet from the section line and well within the setback. So once that permit gets approved, it goes to drilling and we look at anti-collision, tweak it for geology. And this was another miss. We, once again, that setback was illustrated at 330 feet. And so we assumed it was right because it looked right. And that is another mistake, to diligence that, check that, and not leave it up to others, our own fate. And then as it got to the drilling phase, our guys actually did a great job. They executed it perfectly. They never strayed more than 31 feet south, which based on what we were trying to do, giving ourselves a 50-foot buffer would have left us right where we want to be from a spacing perspective and from a regulatory perspective. It was then after that pad was done drilling that we sent all the final surveys and we get the as-drilled plat shown in the previous exhibit. And that's when it was discovered and we self-reported. That was the last well on the pad for the rig, being the southernmost. And it subsequently moved off and completions is scheduled to come on at the end of next month to stimulate that 9-well pad and DSU. The changes implemented, number one was update directions given to the well planners and everybody ahead of us. The game starts 1.5 years before, so I can't say it's, our drilling engineer's utmost focus 1.5 years before every well. It's just not feasible with the manpower we have. But updating directions, giving more visuals to where our third-party well planners, it's very spelled out black and white, how the setbacks are and how we plan these things. The other big thing that will prevent this from ever happening again is instead of doing a point-to-point lateral azimuth based on X footage from a section line, well planners will begin mirroring the section lines in azimuth. So in this case, you would have drilled at 180 or a 270 degree azimuth due west until you got to the second section, and then it would have turned left a little bit to match that irregular shape. We also increased awareness and training of setbacks, regulatory across top to bottom field personnel and anyone that touches a well plan, a permit, et cetera. And then we made personnel adjustments. There's a certain amount of trust given to well planning and all services, and just want to make sure we have the right people doing that to keep us in situations where we're spending.
Okay. Well, real quick, Tom, this is a fairly comprehensive postmortem. Would you say that XEL, or you as the person in charge for XEL of their drilling operations, would you say you feel comfortable that you've identified the problem and it won't occur again? This same problem won't occur again?
Yes, sir. 100% comfortable.
Okay.
We've sourced the issue and it will not happen again.
Okay. Let me move you to exhibits I and J. No. Exhibit G.
Yeah, just real quickly, we'll show the top image is the plat submitted with the permit. And I just highlighted there showing that the heel and the toe of the well at 610 feet from the south line, which is 50 feet north of the setback. The next image down is the permitted plan, and that plan intersects the landing point in TE at 610 feet from the south line. And what I want to show here is you can see how the setback was drawn to the south, and that's drawn at 330 instead of 560. Which is why when everybody looked at this across XCL, it's like, we're good.
So it's
essentially
someone drew it wrong. There's not identifiers on this picture to show that it doesn't call out 330 feet. So you'd have to count those individual boxes if someone was looking to find this. But because every other unit you operate is rectangular, there was really no reason to suspect or check something like that. Is that accurate summation?
Yes, sir, that's correct. It's in a rectangle. As long as if you start and end in a straight line at 610 feet from a line, then you're always at 610 feet.
Okay. That makes a lot of sense.
So then if we go to exhibit H, what I had the well planner do here is move that same plan that was permitted, approved, and drilled and put the correct 560 setback on it. And you can see if that would have been correct, we obviously very much would have known that this plan is flawed from the beginning. And we need to adjust our procedure in this well plan. And then the bottom image shows the as-drilled surveys against the plan, just to show it wasn't a drilling issue. My guys executed, actually proud of them. That's as good as we do, staying within 31 feet there. And so it was a planning mistake. It's a planning mistake that's been addressed. It will not happen.
Okay. And just to be clear, that planning mistake, it sounds like it's shared with everyone, right? There's third-party planners, there's XCL, which I would say XCL bears responsibility for both of those in some senses. But it also was submitted to the division and approved, even though it was clearly not in compliance with the spacing order. And that's not to put anything on the division. It's just to say that these mistakes were really truly buried in this information, and no one would have seen it unless they were looking for this mistake. Is that accurate?
Yes, sir.
Okay.
And we do take accountability for our third-party contractors. That's not an excuse, and like I said, we fix that.
No, absolutely. Moving on to exhibits I and J, if you're comfortable and ready for those. Exhibit I.
Yes, sir.
You mentioned earlier something about enhanced surveying. Can you kind of walk through and explain to the board what XCL does to survey their wells, what industry standard is, and kind of the impact of that?
Yes, sir. One of XCL's hallmarks is technology and data. And anywhere possible, we try and employ that to make better wells, more economic wells. And precise placement of well bores improves economics and maximizes the resource recovered. And we're big believers in this. We think the well's productivity and our ability to produce these high density cubes is based on our accuracy with how we place our well bores. And so every survey we take along a well, which for 2-mile laterals, over 200 surveys, has an error associated with it that's mathematically calculated. That's a cumulative error. So as you drill the well from top to bottom, that ellipse of uncertainty gets bigger. And so there's always a point where we think the well is, and then there's an ellipse of uncertainty drawn around it that could be the well could lie anywhere in that area. Industry standard off-the-shelf tool codes is what most companies and most drilling rigs in the US use. And it's just a standard MWD code, and you just know that there's a error with it. XCL goes both from a time standpoint, financially, we go a few steps past that to just reduce that uncertainty and make sure we know to the best of our capability where the wells are at. The first thing we do is infield referencing. It's the process by which we send guys out ahead of the rig and take magnetic shots and magnetic readings of the magnetic crustal field, both at the toe and the heel of the well. That's shown on the images to the right. And so the left image is the standard out of the box MWD model. And that's a global magnetic survey. And as you can see, there's not a lot of resolution. It's just kind of like, this is what we think it is in the area. And it's generally right. If you go over to the far right picture, that shows you when you do these ground shots, how much more resolution you get. And so the more you know the local magnetics, the more accurate your surveys are. The second thing we do is multi-station analysis. That's a process by which we take raw survey data at the time it's surveyed. We actually send it off to remote centers in real time to remove systematic errors, and then they send it back. So all 200 plus surveys we get during the well, we are sending that survey in, having a third party look at it, correct it, send it back to us, and then we proceed. We voluntarily do this because we think it's the right thing to do. We think it helps our wells. Now, how all that shakes out, Mitch, if you please go to the next slide, is this is an example of a well that would look kind of like the Maximus 58 does. Circus on the east there with a nudge south, and then drilling a lateral east to west. You'll notice I had the ellipses of uncertainty drawn along the wellbore, and you'll notice those get bigger as you move from east to west or right to left. Now, there's two different colors on there. The orange ellipse is what the industry standard ellipse of uncertainty looks like, and the blue ellipse is what XCL employs using MWD plus IFR plus MSA. Yeah, as you zoom in there, basically at TD of the well with a standard tool code, there's a 585-foot ellipse of uncertainty. So we know mathematically that well is somewhere in that 585 feet, and we think it's in the center of it, but that's a large ellipse. With what XCL does, we increase that accuracy by about 320 feet, about 54%, to where at TD of our wells, the ellipse of uncertainty is 265 feet. Just as an example on this well drill on the setback. So if we drill a well right on the 560 setback with standard MWD, and then XCL came along and drilled a well 150 feet past the setback to the south, there's a chance that that standard MWD survey could actually be further and closer to this, like further across the setback than the XCL well. And they wouldn't even know it. And so this is just a little example of us, our attempt to be prudent operators, our attempt to do the right thing. We think it's the way to go, but we do know, even though we encroached into the setback, that our surveys are more accurate than even if we would have been on the other side of it.
Let me ask what you said and see if I can sum it up in a different way. If XCL had gone with the standard out-of-the-box survey that most companies use across the United States, would you have known this well was beyond the setbacks?
Yes, we would have likely known it was still beyond the setback.
Okay. How much?
The degree of accuracy that we would have known that by would have been about 54%.
Okay, so about half is confident. Okay.
Sure.
And what you're saying is with this heightened surveying that XCL does, standard surveying, you could both believe it to be in the same spot, and with the standard out-of-the-box surveying, they could actually be 160 feet closer to the section line than you, without either of you being able to tell from the modeling.
Yes, sir.
Okay.
That's correct.
With that, I believe that's it for you, Mr. Castens. Is there anything you'd like to add to your? Oh, did I miss something?
Just to address one question that you asked. So this was our last well on the pad. This was the 9-well pad. So the drilling moved off this pad after the subject well. It was about a month later that the post-drill plat came in. At that point, both of our rigs, one had moved to a 13-well pad, the other was on an 8-well pad. And so moving a rig back to drill one well and incurring that extra capital of a rig move, 2 extra rig moves, both there and back, we yielded it uneconomic. Additionally, completions is scheduled to complete this well next month in July. And so without leaving those other pads early, there was just no way of us being able to come back in an economic fashion and drill the well.
Okay. Thank you. That was helpful addressing Ammon's question from earlier, Mr. McDonald's question from earlier. There was one other question asked earlier, and you addressed it, but in a way that I wasn't totally clear on the answer. I'm going to ask it again. I think it was Mr. Church said, how much of the wellbore is beyond the setbacks? You said 2/3. Just to clarify, 2/3 of the wellbore is closer than 560 feet, or 2/3 of the wellbore is within the 560-foot setbacks?
2/3 is closer to the section line past the setback, with the maximum distance being 115 feet or 114 feet, but much of the lateral being much less than that.
Okay. In your expert opinion, was the deviation of this wellbore unintentional and unavoidable?
Yes, sir.
In your expert opinion, is completing this wellbore, the subject well, as drilled and located, the best way to maximize resource recovery, prevent waste, and protect correlative rights?
Yes, sir. If we don't complete this well as is, there won't be a well within 800 feet of the unit boundary, and it'll leave a lot of resource.
Okay, thank you.
Additional thing I'd point out on that is because of this being a laydown and the subject units to the south being stand-ups, there won't ever be a 2560 well in place. So that would remove that as a possibility as well.
So essentially, if this well wasn't drilled now, it would be uneconomic to come back and drill a well later, most likely. And because stand-ups below you, that will be permanentized waste because there likely won't be a 2560 drilled between those stand-ups and laydowns.
Yes, sir.
Okay. I appreciate that. I have no further questions for Mr. Castens. If the division or board does, I'll turn over.
Division?
Yeah, just a few clarifications. To Mr. Mayo's point, we do recognize that the division did approve the permit as submitted. We also believe that XCL, it was an honest mistake on XCL's part. We don't believe that anything was done deviously. But to that point, setbacks are there to protect correlative rights. And since those setbacks have been encroached upon, has XCL gained some sort of advantage to other mineral owners based on the fact that you've encroached upon those setbacks?
I'm going to kick that to Mark, our reservoir side, who will testify next, and he'll be able to satisfy that.
So question here. I know I deal with a lot of permits, and is there any around the area with the 330 setback on the edges that, around the perimeter that you have seen in the area?
Oh, yes, sir. The actual, and Mark will get into this, but the actual setbacks on the other side of the unit in question are currently approved at 330 feet due to the nature of the stand-up units.
Okay, that's all I had.
No further questions from the division for this witness.
Board, any questions for this witness? I'm going to ask a pedantic question. So the township range section system, is a grid ideally. It's a bunch of squares. But there's that classic problem when you're trying to make a map, a flat thing fit onto a globe. It doesn't fit. That's why you have Mercator projections and all those things. Is this deviation from just an east-west section line because of those problems that you've got to make corrections periodically as township and range was extended across the country?
Yes, that's correct. It's when you're trying to put squares over a round surface.
Okay, thank you.
I'm looking at these plats here. This first one says it was Exhibit G. It says the line was incorrectly drawn at 330 instead of 560. Now, did you start drilling based on a 330 setback or not?
No, we believe that it's 560.
Well, I think just to clarify the question, I think what she's asking is the plat, the mistake on the plat was that it was drawn at 330-foot lateral setbacks instead of 560. That was one of the mistakes in the planning.
Right.
She's asking if the drill rig started the wellbore at 330 or started it correctly at 610.
Right.
Does that make sense, Tom?
You're talking about when it landed the lateral at the heel?
Well, basically, she's saying the mistake on the plat, did you guys carry that out in the field and start the drill rig at 330 feet accidentally? Or did you start it at 60?
Just to clarify, I'll jump in for a second. The plan was to be 610 feet from the section line, both on the east and the west side. And when you draw a straight line between the rectangular unit, all would have been well, but because the southwestern corner of the DSU dips, the plan encroaches on the unit boundary. After we drill the well, we had an additional line drawn that would be a check and balance so that visually when you look at it, you would see, did this work? And that check was drawn incorrectly. So we didn't drill at 330 feet. That would have been another visual opportunity to see there's a problem.
And yeah, the drilling rig engineers, everyone up and down, thought the setback was drawn at 560 when we showed up to drill it, but it was drawn at 330.
Yeah, so that was just another check and balance that could have been capable of seeing this problem.
So,
but we never drilled at 330 feet from the section line.
No.
So did you discover this mistake when you were done drilling? When you did subsequent post-drilling surveys?
It was, yep, on our post-drill plats that we send to a third-party surveyor. So we have third-party surveys and we send those to a third-party surveyor that matches up with the surface and gives us an exact footage of, here's the lateral footage within the setback. And we do that just to make sure we never accidentally perforate outside of the setback.
So it's a subsequent process after drilling for the completions team to know that their heel and toe perforation are going to be at least 330 feet away from the section lines. When looking when their legal take points are for their heel and toe perforation, they discovered that the center of the lateral actually encroached because of the irregular shape of the unit.
And the closest you ever got to the section line, just to clarify, is 446 feet? Is that correct?
Yes, sir. Yes, sir, that's correct.
Which is why the request is for the setback to be at 445 feet, just for that buffer.
Right.
So what condition is the well bore in right now? It's all set for completion? Does it have pipe, completion pipe cemented in, or?
Yes, sir. It has the casing program top to bottom cemented in, and it is sitting along with its 8 other wells on the pad, waiting for completions and completion prep.
Okay.
Did the original survey plat not show there was a deviation in that southern line? That they were
The-
gonna need to,
The actual township line change, I don't believe it did, which I think is the part of the
it
problem.
was just, it didn't show that little divot there. Okay.
And one thing we check as engineers is the heel and the toe. And so the flaw was you check the heel at 610 feet from the section line, you check the toe at 610 feet. And once again, back to the rectangular nature, it's like, oh, we're good. And this is an exception to the rule and something that we needed to adjust our procedure to make sure it never happens again.
Question? So, yeah, that was a good question, Levon. So this map with the bend in it, that's not on the, that bend was only discovered on the post-survey. That wasn't on an original plat map?
Which exhibit are you referring to?
Well, I think what they're trying to get at with both questions, Tom, and maybe this is for all you guys, is essentially, you do a plat for approval of the APD. Was the tilt down in that west half of the actual section line, was that visible on there? And if so, shouldn't that have alerted you guys to kind of that mistake even before you began drilling? And I think, is that the question?
Yeah.
Somewhat close to. Was that depicted on the plat that you submitted with the permitting?
I did not look at the plat prior, but I do believe it was, and that's like why one of the changes implemented was training on internally at XCL.
If the heel point of the lateral is 610 feet from the section line and the toe is 610 feet from the section line, in every other unit we operate, every other point along the lateral will be 610 feet from the section line. So the mistake was not adjusting to calculate on every point along the lateral because it is not a parallel line. And so that was, to Tom's testimony earlier, something we have changed. And although we won't encounter a unit like this again, we are going to check along the lateral in the future as a precaution.
This sounds like a classic mental shortcut we all make to make life simpler, right? And they work 99.5% of the time, and sometimes they don't.
I would say at one of the traps, development drilling for oil and gas has been great at helping us reduce cost and reduce surface impact, be more efficient. But there is a mistake that there's a lot of copy and paste, and that's why we're able to get more efficient. And it's our job to make sure we check all those boxes because there's always a little difference. And in this situation, it wasn't noticed and it caught us. And it certainly was a reminder, I can tell you, in the drilling and planning department that every well should be treated as its own.
Because I would assume that at the top of these sections, you were 160 feet off the setback because you drilled them all straight. Is that correct?
Correct. Yes, sir.
Any other questions for this witness? Back to you.
With that, I'm done with Mr. Castens, and I'll move on to our final witness of the day and the final couple slides. Mr. Gravy, standing in for Mr. Sigler, the geologist, could you please, obviously this was testified to moments ago, but before you start, could you please state your name and spell your last name and business address for the record?
Sure. My name is Mark Gravey. Last name is spelled Graeve. I'm the Executive Vice President of Reservoir and XCL Resources. And our office is at 600 North Shepherd Drive, Suite 390 in Houston, Texas, 77006.
Okay. And you recognize these exhibits, and were they prepared by XCL staff under your direction or supervision?
Yes.
Okay. Supplemental Exhibit K. This was testified about at length only moments ago. What summary does the board need to hear relevant to this request?
Sure. This was submitted again in order 130-21 earlier. This shows the rotation of the principal horizontal stress from east to west across the field, which is an indication of direction the fracture will propagate. You can see here we are on the western side of the position where the principal stress is more north-south.
Okay. And to maybe get to the heart of it, Supplemental Exhibit L. This is, we've had a lot of talk today. The board has had a lot of talk today about transitional zones and about setbacks and about drainage ellipses. Can you kind of sum it up here? And, there's clearly a mistake. The well was drilled wrong. Do you believe, does XCL believe that's going to impact the offset units?
In Exhibit L is a depiction of the current setbacks of the DSU. So the wellbore in question is shown in red. Distance from the setback, you can see, encroaches beyond that green line in the center of its setback, 560 to 445 feet. South of the unit are the units that Matt testified to earlier that currently have 330-foot setbacks from the section line. And this was actually an observation made by Dustin Doucette. We offered to review these materials with him since he was unable to attend today. And this was something he really pointed out to us as being important to him, that currently the rights to produce within the distance from the section line are actually greater south of the position than north of the position. In addition to that, the drainage that has been presented in cause 130-21 earlier today by ourselves, as well as by the same logic process in cause 130-16 by Oventive, is consistent with the decision that, or the interpretation that it appears this will not encroach or impact relative rights. I think that is confirmed by their decision not to object to the wellbore.
That makes sense. The board has heard on numerous occasions that a rock doesn't know which direction the wellbore is oriented. That a lay down or a heel toe perf acts the same as a perforation in the middle of a wellbore. What you just said, I want to kind of get back to briefly. The heel toe setbacks on the offset units, Dustin pointed out to you that they essentially, their perforations are at 330 feet from that section line. Even with the mistake, your perforations are 445, 115 feet farther away from that same section line than Oventive's wells. Is that right?
Correct.
And according to Oventive's filing, the wells on the offset units have been producing for about 11 to 12 years. Did XCL notice any offset drainage, any evidence of offset drainage from those wells on the subject unit?
Not to my knowledge.
Okay. And finally, just to remind, did Oventive appear here today and express concerns, or the tribe or Sitla, about being drained by this well being completed?
No, do not believe it.
Okay. With that, I have nothing further for Mr. Gravey. Division Board would like to ask questions.
Division?
So it's your opinion that XCL doesn't gain an advantage from this violation of the setbacks, is that correct?
That is correct. I believe it is consistent both with the material Oventive presented in cause 13016 and that we presented in 13021. Additionally, I believe that if they did believe there was an advantage, that they would object in order to protect the correlative rights there.
Okay, and then on supplemental exhibit K, just a quick clarification. Your stress regime in here, I'm assuming that this is a compression, these stresses are under compression, is that correct?
I do not actually know the answer to that question. These stresses were interpreted by our VP of Geology from image logs of the borehole showing the induced fractures and fractures.
Okay.
If that's something you need to know, we can get an answer and get back to you, but
I'm just making the assumption that based on the maximum stress and the propagation of the fractures, that it has to be a compressional stress regime, and I just wanted to verify that was correct.
Sorry about the. Sorry.
We have no further questions for this witness.
Board, any questions? Yes.
So do you have written documentation to show that Oventive, the tribe, and Sitla have no objections? I mean, you said, but is it in written form?
No one wrote in, "We don't object." But they all received notice, just like in every one of these hearings. Oventive actually filed a response and said, "We'd like to preserve our right to appear and object here today if we believe it's appropriate." And they didn't show up. And in conversations with them prior to this hearing, they said, "The tribe and Sitla never contacted us. We've been calling them for 2 weeks. No one expressed concerns." So Oventive didn't have any concerns, which is why they're not here. So no one wrote down, "We don't object." If they had, we wouldn't be here at all because we'd be at the division getting administrative approval. But to be clear, no one said, "We don't object," but no one appeared to object. Appeared here to lodge an objection.
So the offsets often have some conservative features built into them to protect correlative rights. Would any of the witnesses be willing to comment on how much conservative the 560-foot setback was based on the stress regime and fracture half lengths and all those things? Is anyone prepared to comment on that?
Is that squarely in Josh's universe, or is that one of you guys has a chance to?
No, I think it would follow the same logic that was both submitted by us and other operators of the setbacks that would say that it should be more than 100 feet of optimism, well more than that. So in the 330-foot setback that Oventive currently has, we would not object to them putting a perforation in wellbore at 330 feet.
And I think maybe more importantly, I think what you're getting at is that the board has the authority, if it chooses to approve this request, which we believe it should be approved, but if the board chooses to approve it, it has the ability to make offset orders to essentially allow an offsetting determination so that there isn't a competitive advantage giving to XCL over Oventive. In this case, what I think is unique about it is it almost is in a situation where the offsetting compensation would be moving their setbacks farther away from the section line. So I don't think there's any opposition to allowing them. Clearly, they've been producing from 330 feet from the section line. So just with that clarification.
Well, and maybe just help me understand. The 560 setback is somewhat designed so there can be a lease line well added in later, versus there's going to be drainage from 560 feet because we're up to 330 now to 100. So the problem here is you have a stand up and a lay down, but looking at the current well pattern, it looks like to me Oventive will be switching the drilling unit south of this to a lay down because they have further south and Javelin just to the west have switched to lay down anyway. So I think ultimately this area would be all lay down. You'll be able to do a lease line well south of, right on the lease line, and no harm, no foul. So
Possibly. The only,
I don't know if they will or won't. They certainly could from the interpreted stress regimes. Oftentimes you choose to acknowledge the direction of the parent wells for planning purposes. So I can't speak definitively to their plans, but I agree to your point that they could. I also could see logic in them choosing to offset existing wells rather than drill across the wellbore. And it isn't terribly common to drill perpendicular across wellbores, so they may choose to acknowledge the units. I'm not sure which path they go, but as it sits today, they can propose and drill wells and initiate fractures 115 feet closer than were requested.
thank you.
Any other questions from the board? Seeing none, are you wrapped up? Should we be moving over to the division now?
I'm done. I give. I think I'm wrapped up. I'm going to try and get an accurate exhibits. I'm done, and I'd like to move for admission of our exhibits used here today. Exhibits C, D, E, F, G, H, I, and J. So A through J, and supplemental exhibits K and L.
A through J and K through L, huh?
That's right.
Any concerns with entering those exhibits into the record?
No objection from the division.
Any concerns on the part of the board? They may be entered into the record. Huh?
I'm done with my case in chief if the division has one. If not, I'm happy to sum up.
Division, over to you.
Thank you, and thank you to the board for all of your time today. The division has reviewed the request for agency action and the supporting exhibits and for the exception location in this matter. The division had further conversations with Mr. Mayo and received the supplemental exhibits. With those filings and the testimony today, the division does not oppose the exception if the board finds that XCL has shown good cause and that it has not gained a competitive advantage. Utah Administrative Code R649-3-3 subsection 5 says whenever an exception is granted, the board or the division may take such action as will offset any advantage that the person securing the exception may obtain over other producers by reason of the exception location. So if the board determines that to grant the exception location, if the board determines that XCL has gained a competitive advantage, the division just asks that the board consider if that advantage needs to be offset. And that's all that we have from the division.
And what sort of offsets would you propose as being, could be considered? Huh?
I'm not necessarily suggesting this be done, but the most extreme case would be to make XCL plug the well back and drill it within the offsets, but I don't think we're advocating for that. But
I guess I have one other question for the division. If the well were abandoned and then plugged, would that result in a stranded resource here? Because
potentially,
yeah.
Just give them a chunk of the well, everything's solved, right? No, just kidding.
Any other questions for the division? Huh? Do you need to sum up or make any final statements, Mr. Mayo?
Yeah, real quickly, what I'd like to remind everyone here, I think, this is one of those matters I don't want to be here before, and the witnesses don't want to be here. They take pride in their work, and they do a really great job at it, but mistakes happen. And this mistake is clearly excusable. It's understandable given the fact that they don't operate any other units that look or interact like this. It's understandable given the fact that it slipped by the division, who does a very, very good job reviewing APDs. This is unintentional. And the truth is the board has a decision to make, right? Whether to punish someone for making a mistake or whether to take into consideration the views of all parties who may be impacted. The division, after review and consultation, doesn't oppose. Ovintiv, after lodging a response and preserving their right to be here today, didn't show up to oppose. The tribe and state, who both received full notice, evaluated it and chose not to file a response. And so in that situation, I think we have to look at this and say, the only right decision, if it's wasting from 810 feet to the section line and potentially forever, or if it's allowing this mistake knowing that there is minimal, if any, impact to the offset owners because they didn't approach and lodge objections, I don't think there's really any determination to make but to say that that satisfies the good cause requirement and the request should be granted. And with that, I'm happy to submit. And before I do that, I'd really like to take a moment and appreciate the division and board. This month has been chaotic. There has been a lot going on. There's been supplemental exhibits to corrected exhibits to motions to, it's been a lot, and I really appreciate the efforts from all involved, especially the two council who stepped in to cover for Liz and Trevor. So with that, I'd submit.
Board, do we need to deliberate at all, or would someone want to make a motion? Should we go out and have a little chat about this?
Let's do 10.
I think so. Okay. We're going to go off the record briefly, and we'll make this as quick as possible, huh? Not by 6, though, huh? We are back on the record, and I would entertain a motion from the board.
I would move that we approve this exception location as requested.
I'll second.
Any last comments? Seeing none, all those in favor say aye.
Aye.
Let the record show that was unanimous, and that concludes our last item. Oh, Mr. Mayo, could you draft the necessary documents?
If you'll let me leave, I will do anything. Wait, we had one question over here at council table. Is it your birthday?
My birthday was 2 days ago, and yesterday was my son's birthday, so tonight we're all going out for a dinner.
Well, happy birthday. Sorry for. Yes, I'm happy to take care of the order.
Okay, thank you. That is the last item. Is there a motion to adjourn the meeting? Yes. All right. Thank you very much.
Thank you.